I can assure the court I will refer to one case in my argument. But that it is there, I don't know what the applicants, the other applicant and the state will refer to. May we hand that up, my lord? And then coupled with that, we have prepared solely, hopefully for the benefit of the court, a more detailed chronology of the matter. We don't believe something really material would turn on that. The state has indicated that it hasn't had the opportunity to go through it, and they may want to add a note to that, and we have no objection, of course. It is there to assist the court just to have the chronology on a separate piece of paper, should it be necessary to go to the chronology.
Yes, thank you.
Mr. Mpofu asked me that he just needs to bring something to the court's attention before I start with my address.
Yes, Mr. Mpofu.
Thank you, my lord. Yes, I had requested Mr. Rue, just so that the proceedings of this morning are out of the way, my lord. We're indebted to your lordship. We took advantage of the break that your lordship gave, and also because the judgment is not too long. It was just to record, please, for the record, my lord, that we have instructions in respect of the matter this morning. We now have instructions, my lord, to petition the Supreme Court of Appeal in respect of that matter. Just to place it on the record. The lordship will be served with the necessary papers at the correct time. Yes, court please.
Yes, Mr. Rue.
Thank you.
Thank you, my lord. If I may, right at the inception state that we're not bringing this application on the basis of the so-called unreasonable delay, going back to the history of this matter. We bring it on the basis to say where we are today. This is the situation, and our section 35(3) of the Constitution dealing with fair trial rights would be premised on at the present time where we are, and to then demonstrate to the court why we say that there is an infringement of the fair trial rights of, if I may refer to it as Talis, that would be easier, not to confuse accused 1 and 2 to Talis. My lord, it is obviously for Talis to convince you on a balance of probability that there has been an infringement of the fair trial rights to the extent that there is insurmountable trial prejudice. We understand that anything less than insurmountable trial prejudice would not suffice. In this regard, we would, not extensively, but we would deal in some detail with the case of I just get you the reference, my lord, of Botma and else. That is a case relied upon by the state, and we believe that the case is really instructive, and we will not deal in detail with it, but only relevant parts, understanding that we have a high bar to cross. It is not that we can generally make out a case, it must be more within the category of an exceptional case that we have to make out before you. The third contention is this, my lord, that we fully understand that generally trial prejudice is a matter for a trial court in the trial. Although you may sit in the capacity as a trial judge, it is a matter for the full trial. And again, our application would only be entertained by you if we can show to you that there is no need to go to the trial merits for a proper adjudication in order then to determine the trial prejudice. We will return to that when we deal with the different charges, and we would submit to you, my Lord, that the only approach open to us would be very close to an approach when you argue an exception. And that is, we're sort of bound to accept the allegations in the indictment for purposes of this application, and then to demonstrate to you that even by accepting the allegations, that the trial prejudice not only exists, but that it is irreparable or insurmountable. The further factor, my Lord, and it all comes out of what I'm submitting to you, comes out of the Botma case. And in that matter, it was made clear that trial prejudice would depend on the circumstances and all relevant factors to be weighed on a case-by-case analysis. So what may or may not be trial prejudice in another set of facts, that's interesting. You can apply the principles, and we hope to apply the principles laid down in previous cases and then deal with the facts of this specific case. We also understand that the irretrievable loss of some evidence does not give us a clear passage to the justifying inference of insurmountable trial prejudice. That was also made clear in the Botma case. We also accept that there will be a balancing act to be applied by this court, and my understanding of the Botma case is this: if it's a very serious charge, of course trial prejudice remains trial prejudice, but the bar would be high because of the rightful demand of society to see that a person who's accused of a serious trial must generally stand trial, unless it's exceptional. The corollary is true, and that is, if the seriousness of the trial is a lesser degree, the court may be more accommodating in looking at trial prejudice. And I think in the Botma case, they use the example of a shoplifting 15 years ago and say, what is that life all about? And we understand that distinction, and we will apply it. But the fact remains, my Lord, that even if an offence is serious and very serious, if the trial prejudice is insurmountable, it is a conclusion, because the integrity, the fairness and the integrity of the trial must remain paramount. We also say to you, my Lord, that if you have regard to the Botma case, and it may be helpful if I may refer to it in the state's bundle, it is at, my Lord, there's an index. It's not my bundle like this. I asked for a copy from the state, but it will be helpful just to have that open. It's the one that's not in a file or in a file cover.
I see.
It's like a loose leaf document.
You mean the one that was handed by you?
Yes, I handed that up. But it's not in the blue file.
It's not in the blue file.
Not a blue file.
This is
No, it's quite voluminous, my Lord. That's the document. If you maybe just, it's not my bundle, but the Botma case is I saw it in the index.
okay.
I think it's the third item there, my Lord.
29 through 47.
Yes, thank you, my Lord. Now, what is important to bear in mind are two things in the Botma case. Of course, we accept the principles laid down there. We have no choice. But two things are important for purposes of the present argument. The one is that the Botma case on the fair trial prejudice was decided not in a trial but in a separate application. So it can happen. The second one that's a very relevant distinguishing factor is this. Botma case deals with the complainant that was raped when she was a minor, which would explain the egregious nature of the charge and how serious that is. But there's something far more important in the Botma trial, and that is, although it was an application of 33 years, or as the court referred to as close to 4 decades after the alleged rape incidents, one thing was intact in the Botma case, and it is this: the complainant was available as a witness, and the accused was available as a witness. And the court rightfully, in analyzing the Constitutional Court, in analyzing the facts, pointed out the fact that some of the evidence may not be retrievable anymore, and the fact that some of the witnesses who may be called may have some difficulty to properly or sufficiently remember detail. At the end of the day, in the Botma, the two major ingredients were there, and it was not the case of Mr. Else that his memory failed him. It was rather that the secondary evidence around it was compromised, either not available or that could not remember well, and so on. And the court then correctly found that the fact that some of the evidence was irretrievable does not equate that to insurmountable trial prejudice, and it must be right. This case is different. What we will demonstrate to you is this, and we will demonstrate it on an acceptance of the charges, but we will demonstrate that Thales is a company standing trial by virtue of Section 332, which means that vicarious criminal liability is imputed on them, whatever the directors did wrong. They must stand in for that. That is in the nature of 332. So it's not a case like in a Botma case where you have the accused and he can tell his story. It's a case where the company is dependent on, for the state's purposes, the offending directors. And it is in that sense that we will ask you to look at the charges in two categories, without commenting on the merits of the charges. It's not necessary. The first category of charges would be found in relation to Thales in count 1, which is a so-called racketeering charge, consisting of 783. We know of another 8 acts being added, but I stay with the existing indictment, 783 acts of racketeering, meaning it's premised on the basis that Mr. Sheikh made, over the period 1995 to 2005, various payments to or on behalf of Mr. Zuma. That is the allegation. And the total amount of this is about 3.75 million over 10 years. The second count's not relevant to Thales, it's only relevant to Mr. Zuma. And the third count is referred to as general corruption. But in reality, the general corruption is premised on exactly the same facts as the Racketeering Acts, the 783 payments directly or indirectly to Mr. Zuma. The fourth count is again not relevant to Thales, and the fifth count is termed specific corruption, referring to a specific meeting in March 2000. The sixth count is connected to the fifth count in the sense it's money laundering, but it is the state's allegation is it is the payment of what was agreed at this March meeting. And they say it was a disguised payment made. And I'm going to separate it for the time being between counts 1 and 3, the racketeering or the general corruption, and counts 5 and 6, the single counts of specific corruption and money laundering. Now, what must be common cause is this. The state alleges that Mr. Sheikh made these various payments to Mr. Zuma over the 10-year period, and that Thales is also criminally liable for those payments because there was a common purpose between the representative, the director of Thales, and Sheikh to make unlawful payments to or on behalf of Mr. Zuma. I'm going to forget for the moment that some of the payments occurred before Thales was in South Africa, and some after Thales had nothing to do with that. It's not important, it's merit. I don't want to go into merits. But this is the fact that should be common cause. There were only two persons acting on behalf of Thales in that period in South Africa. Not at the same time, but at different times. And that was Mr. Manoy and Mr. Tetart in respective periods. So it is not too difficult to understand that this common purpose then must have been connived or formed by either or both at the separate times, Mr. Manoy and Sheikh, or Mr. Tetart and Sheikh. Mr. Manoy is dead. He died in the beginning of 2021, and Talis became aware of it. It's in the heads of argument. I'll take you there. Towards the end of 2021. So it will be seen, paragraph 4 of the heads of argument. Manoy died on 31st December 2020, and Tetart on 7th September 2020. But Talis only became 22, but Talis only became aware of the death of Tetart in October 2024, because they've all long retired. So now we go, and I'm talking about the general corruption and the racketeering charge. And it's the bulk of the trial. One can just work out to prove at least 783 payments over a period of 10 years would require substantial evidence, as opposed to one count of specific corruption and the associated count of money laundering, which is far more limited in scale and in time. So now Talis is in this long part of the trial on all these payments without a witness. But it's common cause, the witness is dead. Both of them. Yeah, it's certainly possible to some extent, though fragmented, challenge the evidence and say we deny a common purpose and rely on whatever would present itself in the state's case to, as far as possible, challenge the evidence. But that itself is compromised, but not non-existent. I can't say that, because you can't get the instruction to say, well, this has just come out from a state witness. What do you say, Mr. Tatar? Or what do you say, Mr. No? You don't have that. So the challenge is compromised. But one thing is not compromised, but non-existent. Who's going to give evidence? Who is going, the state has now presented its case, and who is going to give evidence on behalf of Talis? There is no one that can give evidence. I will come to the state's argument to show why that could never be. But factually, the only two persons who could give evidence are dead. So it means that Talis goes into this trial in a supine position on the majority part of the trial, and that's where it will remain. It has no case to offer after the close of the state's case, because it has no witnesses. The state comes with a solution, which is not a solution. And if I may refer you in this regard to the state's heads of argument, at page 39, and I will deal with paragraphs 39.5, 39.6, 39.7 and 39.8. 39.5 of the state, they say Mr. Manoy testified for the defense in the Sheikh trial. But you can read that evidence. That's not offering Talis any evidence to refute a common purpose. It's not relevant to that. And even if he did, and it does not, but even if he did, what is it that we say to the court? The state says, not in the answering affidavit, but now in the heads, and that's to rescue, to try and rescue the position. Say, well, we won't object to the admissibility of the evidence in terms of the so-called Hearsay Act, Section 3. But we're not accepting the probative value. What does that mean? So you have naked evidence on record with no value. That's in any event not relevant to the true dispute of common purpose. The second difficulty is Talis formed no part of that trial and could not test any evidence. It could only afterwards read findings that it wished, if only I could participate, I could have presented evidence to the contrary. But that's neither here nor there in this matter. Then in 39.6, at page 39 of the statutes, they say, but hang on. What about Mr. Sheikh? What about Mr. Sheikh? He's a compellable witness. And my best answer is, yeah, right. Yes. He's been found to be unreliable, not to be credible, not only by the trial court, but by all the other courts, the SCA and the CC. Why does the state not call him? He's not even on their list, and I understand why not. Are you seriously, as the state, offer Talis an acceptable escape from standing naked without any witnesses? It can't be. It can't be. There's a further problem with that. When you act in a common purpose, you must act with someone else. You can't have two hats. I am Sheikh, who was a director at some point in time of Talis, and I'm Sheikh in person. And the state does not say that. They accept that when the payments were made, Sheikh did not act as a representative of Talis. That's common cause, and that's accepted. It's accepted in the answering affidavit, it's accepted in the heads of argument. So what is Sheikh going to say? We know. He said to the trial court that they were all loans. But where will it take us? How long will he stand? How long will the state cross-examine him on all the adverse findings? Now, Talis must call him. And what will we do with him if he's not hostile and he says something else? Because he's not really our witness. The best possible way is to discredit him, then he's not there. So it is not a workable option, but more importantly, it's not a fair option. It does not take away the unfairness of being stranded without a witness by offering someone that you cannot use. I've argued both 39.6 and 39.7 of the heads there. Then it says, the state alleges in 39.8 at page 40, Mr. Sheikh should therefore be able to provide Talis with information relevant to the evidence to be adduced by the state against Talis, which, if such information is favorable to Talis, denials of the charge against it, that it accepted the bribe request or intended to conceal the bribe, and that Talis acknowledged and intended to participate in the racket. How? How, my lord? What is it that Sheikh is going to tell Talis? I did nothing wrong. That's rejected already, many courts. I did nothing wrong. So what information is Sheikh going to give to Talis that they can use? Nothing. It is an academic statement that's not worth the paper that it's written on. In 39.9, the state suggests that, as I've pointed out to you, that the state does not allege that Mr. Sheikh made any of the payments to Mr. Zuma underpinning the charge of general corruption in his capacity as a director of Talis, from the date of its incorporation, 1996 to 1999. But he says that does not mean that Mr. Sheikh cannot provide Talis with relevant information and give evidence regarding the state's allegation that the payments were made and received by Mr. Zuma with corrupt intentions. But the state says, you, Mr. Tetart, let's give it names, you, Mr. Monoy, you conspired, you acted with a common purpose. We don't have that witnesses. We cannot answer that. So it means that if we go to trial, or first of all, should we not wait till trial and argue that? We say, my Lord, what is it that I'm going to say in the trial? Stand up in the beginning and say, my Lord, we don't have witnesses on all the 783. We don't have witnesses. And the court will say, well, we will determine at the end of the day the relevance of that. And I said, my Lord, but I can tell you now the relevance of it. I cannot call anyone. I have no one, whatever the witness is going to say, I've no one that can tell me it's true or not true. I can do my best as counsel. But the state says, well, wait, you can call the previous 10 years ago legal advisor and Mr. Dryman, the attorney later on. What is it that they're going to say? And they can, and Talis can waive the legal privilege. Will Mr. Dryman now go into the box and say, I consulted with Mr. Tetart and Mr. Monoy, and they say A, B, C, and D. On that day they say A, on the next payment they say B, on the payment thereafter, because we're liable, criminally liable, on the indictment for all the payments. That's impossible. They can't do it. A, it's second hand, if not third hand. And if they remember, it's irrelevant because they can't substitute the true witnesses. It's just an excuse, with great respect. It's just an excuse. Realizing that there are no witnesses left. Now, when I make this submission, the question is, but Mr. Roux, whose fault is it? If we go to the historical facts, my Lord, it will be a whirlpool of arguments going nowhere. Because we can say, well, state, you should never have withdrawn the matter. And accused one or two, you should never have done A, B, and C. They're all irrelevant because they all took place when everyone was alive and well. And there was a permanent stay application. I'll get back to that. But that's also at a time when witnesses were available. But from 2021, when the state was ready to proceed with the trial, Talis pleaded, no special plea, pleaded, and indicated that it was willing and ready to go on trial. That's not a dispute. And when the deaths occurred of its two witnesses, it was in that period when it was ready, or when he got knowledge, when it was ready to proceed with the trial. So they did not contribute it. They did not contribute to any delay shortly before the death or thereafter. But, and I'm not suggesting that the state did. But factually, if we look back objectively, can the state seriously contend that any history of the matter, long time history, can be causatively connected to the situation we're in? Does the state suggest, with the benefit of hindsight, with objective evidence, that Mr. Zuma, if the trial had started in 2010, 2012, 2015, would have waived all the points that it took now when the trial ultimately started? Why? It's not the probabilities. The objective facts show differently. That they had complaints that they wanted to escalate and wanted to be found on. So there is no causative connection between a application in 2018 by Thales for a permanent stay. There's no causative connection between Mr. Tatar saying to the state A and then saying, I'm not prepared to say A because I was misled. Because we know the trial would not have proceeded. How do we know it? We have the benefit of hindsight. The objective facts show it. So, and that's why I said right in the beginning, my Lord, if I start with blame apportionment, there's no causative connection to that. There's no causative outcome. It is, where are we as we stand here before you? We have an accused person who pleaded in 2021, was willing and ready to go on, that cannot do so. It's paralyzed. It's not paralyzed from the hip, I think it's paralyzed from the neck. It cannot move. That's the position. If we go to the specific corruption, there's some debate. I try to be as fair as possible. There's some debate whether there's secondary evidence. My Lord, I just omitted one thing, if I may go back to the general to complete it. I'm just looking for... I saw my junior desperately waving her hand to remind me. And that is that the state, and I'm going to deal with the one that's relevant to the general corruption and the racketeering, and that would be 3914. That's page 43. And 3914, you will see, is sort of an extension to 3912, and I will return to it because 3912 deals with the specific corruption. And in 3914, the state alleges, it says, or contains, that further to paragraph 3912, where they deal with the specific corruption, it is likely that Mr. de Jamaron and Perrier will be able to provide Thales with information relevant to the evidence to be adduced by the state against Thales, which, if such information is favorable to Thales, denials of the charge against that it accepted the bribe, by coming to that, that's specific corruption. B, intended to conceal the service provider agreement, that's still part of that money laundering one charge. And in 3, a very general statement. C, that Thales had knowledge and intended to participate in the racket alleged by the state. How? What is likely? They weren't here. And let's accept for a moment Mr. Tatat whispers something in, I don't know what, in the ear of Mr. de Jamaron and in the ear of Mr. Perrier. Let's accept for a moment. And where does it take me? Must I now call that person to say, Mr. Tetat said he didn't do it. And the state does not accept the probative value of that. It has no value. State said, oh, we don't object that he can say it. But we don't accept the probative value. Okay, he said it. Empty-handed. Peria says, no, Tetat, Monoy said to me, they didn't do it. Same problem. Still naked. If I may then return to my apologies, my lord.
No problem.
Yeah, and I have a junior that's becoming overzealous now. And 39.14. It's also interesting that the contention of the state, but what about this one and that, is to help Talis to challenge. A, it doesn't help, but B, it can't go so far to say it can substitute the evidence. You have now a witness, because they know we don't. We still strip naked on the fair trial right to have a right to adduce evidence. We don't have that right. We have it on paper, but we don't have it because we don't have the witness. If we go to the specific...
You do have it, but you are being denied that right.
Yes, ma'am. In fact. If we go to the specific corruption, my lord, it is paragraph 24 of our heads of argument, page 7. And my lord, I omitted to ask you, I assume that you would have seen the heads of argument, and I'm definitely not going to read it out and refer you to every case. It's there for the court to read or to again read. And I just propose to highlight what we say. The specific corruption is principally premised on a meeting between Mr. Tetat, Mr. Zuma on the state's contention, and Mr. Sheikh. No one else. Mr. Tetat is no more. Mr. Tetat was then involved in negotiations with Mr. Sheikh that he wanted work share, leading to the disputed agreement to pay an amount of 250,000 to Sheikh. Mr. Tetat negotiated. It was signed by Mr. Jamaron, but Mr. Tetat negotiated. But if you ask me about Mr. Is there any secondary evidence? Yes, my lord, of course. There is, but not secondary evidence really assisting. But there is. But the main witness who can tell us about the meeting and the events is Mr. Tetat. And that's the only distinguishing factor between the general corruption and the specific corruption and the associated charge. In the one, there's nothing. In the other one, there is secondary evidence. Not really exceedingly helpful, but it's there. And on the one, on the first, counts 1 and 3, there's nothing. So should the court be of the view that because there is secondary evidence on counts 5 and 6, and therefore I cannot find that it's insurmountable. That's not our submission, but if that's the finding, that finding should not spill over on the majority of the trial. And you may take a dedicated view of the charges and say, but it does not assist Talis on counts 1 and 3. They're still stranded. And in terms of counts 1 and 3, they're destitute. And the trial can never be fair. We're not suggesting that the court should find on the specific corruption that it does not meet the bar, but I have to make the concession, there is secondary evidence. Whilst the secondary evidence that the state tries to introduce on the general corruption of racketeering is on paper. To say all the legal advisors they may have spoken to them, it's likely. No, my lord, that's not so. That in reality, in summary, is the case of Thales. We will very shortly deal with some of the contentions by the state. And I would reserve that for the 15 minutes in reply to should there be a need to more extensively deal with it. But I just need to refer you to it. That is there, and that is at page 9 of the heads of argument. The first one, under paragraph 28, we put it under headings, is that the state contends that Thales was responsible for the delays before it pleaded. I've dealt with that, my lord. And the absence of a causative chain. And it is in that regard that we give you a full history of the chronology. And if I may say, my lord, if I may say, the very last thing that Thales had in mind was to delay this trial. And this is quite evident from its stance all the time, not participating in any of the fights between Mr. Zuma and the state, standing on one side and making me the highest paid advocate by saying, we have nothing to say every time. And that stance is still there. The application is not brought as a tactical ploy to get some advantage in the life. It's not. We say, this is where we are. And when we came to know about the death of Mr. Tatat, and that's in the chronology, in October, we there and then contacted the state and went to Cape Town to have discussions on what we perceive to be the prejudice suffered. So it's not that we sat back and say, well, at the stage when the state is ready, we're going to raise this nice little point and delay the trial. We immediately reacted to that and said, we have a problem. And it's just to allay any suggestion that we want to delay the trial. We don't. The second point by the state is page 12. To say that the matter is raised judicata because of the permanent stay. That can never be. Because Mr. Tatat was alive. They say, well, Mr. Tatat, you said he was not available, he wouldn't give evidence. A proper reading of all his statements, a proper reading, makes it clear that Mr. Tatat said, I won't give evidence in South Africa in any forum, because the other forum that he's talking about, he was cross-examined by the state in Section 28 proceeding. He didn't want, he was scared to come to South Africa. He complained that the warrants of his arrest out, and he made it clear in the previous statement that he would give evidence in France. And as the state rightfully say, now we have all the platforms, all the teams platforms, they refer to the ICC provisions. Of course, there was provision for us to call Mr. Tatat not in South Africa. It was there. So he was available. The fact that he didn't want to give evidence in any forum in South Africa is a very different question because of the warrants. But there was no finding by the court on Tatat. There was no finding on Monoy as a dead witness. In fact, to the contrary, it was submitted at a time, and I was not involved, it was before my time, that he was suffering from Alzheimer's. But the court did not accept it because of the insufficiency of proof. The court said, I can't make a positive finding. So there was no finding. And the facts are very different. So it must be the same facts, and it's not. It's on very different facts in a very different situation. At worst, it's a variation of that position, but we say it's not a variation, it's a new position that arose post that. It's a procedural difficulty that came to the fore. It can never be res judicata. The court has not decided on the Tart as a dead witness and on Monoy as a dead witness. Then paragraph, page 14. Just after paragraph 48, my lord, the state contends that the deaths of the Tart and Monoy did not change Talis' position, as they were in any event not available. I've just dealt with that. That's out of context. But we fully deal with that in the heads. It's suffice it to refer you to it. Then page 16, after paragraph 54. The state contends that Talis is not prejudiced because Talis was discredited and therefore Talis could in any event not have relied on his evidence. Talis was not discredited. If you read the judgments correct, and it's on the next page, he was not part, Mr. Tatat, of the trial. He was not there to say, okay, what A and B are saying is not correct. This is my answer. He did not have anyone to cross-examine on his behalf. And the court was quite correct in the approach and said on top of page 17, that may well be so. And we accept that he was capable of falsehood to serve his own interest. But it must depend on the circumstances in which the statement was made. Mr. Tart was not there to explain it. And the court said, well, for me it's difficult to find. I can't go so far as what the state is suggesting the finding was. It was not. And it could not be where the witness is absent and has had no representation and no one cross-examining on behalf of Talis. Down the page, page 17, just after paragraph 57, the state contends that Talis is not prejudiced to the extent justifying the intervention sought in the application. That is very much the approach in the Botma case. But bear in mind, in the Botma case, the surviving main witnesses were there. It's secondary witnesses. Here the main witnesses are dead. That's the difference. And if I may take you there, my lord, if I may take you to the Botma case. And I think it's quite handy, and we're always careful just to go to the head note. But there is a summary of paragraph 68 in the head note, but it's dealt with paragraph 68. And if I may ask you just to go to the head note, starting with where it deals with at page 624, my lord. Page 624, the third paragraph. The summary version, it says, held further as to whether the first respondent, that's Mr. Else, would suffer irreparable and insurmountable trial prejudice. That irreparable prejudice had to amount to something more than the disadvantage caused by the loss of evidence that could happen in any trial. Thus, the irretrievable loss of some evidence, even if associated with delay, was not determinative of irreparable trial prejudice. Irreparability in this context had therefore to relate to insurmountable damage caused not to the sources of testimony as such, but to the fairness and integrity of a possible trial. Put another way, to say that the trial has been irreparably prejudiced was to accept that there was no way in which the fairness of the trial could be sustained. That's what we said in the beginning. We accept that in the Botma case, the two main witnesses were still there. It's not our case. If I may, there's just one point that I need to point out. The case is there. Lord, in fact, all the submissions that I make comes directly from the Botma case, where we tried as well as we could to distinguish between the irretrievable evidence and irreparable damage or insurmountable, what we say we have.
Try to wrap up now, Mr.
It's not up. I take to wrap up very quickly after the tea adjournment. If it's this is the.
No.
I'll be very quick, my lord.
Yes, sure.
Then page 22 of the heads. The state claims there, in paragraph 65.5, that the facts speak for themselves and support the state's version. That's a bit rich from the state. When you have the witnesses, and your one witness is dead, but you have the other forensic auditor, that's a bit rich to say it supports them. But what's supporting us if the witness is dead? Nothing. Absolutely nothing. My Lord, then on the point that what should be, and we were debating this, what should be the order of the court? Should the court agree with the contentions of Thales? And we had a long discussion, and we initially said in the notice of motion that that you must find that the trial against Thales would be unfair, or that part of the trial, whatever the way the court's going, and that the court then should instruct the state to stop the prosecution. But I don't think the court can do that, because the state is dominant leaders. So I think what should happen is that the courts...
Sir, just a moment.
that
yes.
The court ruling or the order should be only on the first leg to find that there's irreparable damage to the state's case, that it's unfair to proceed on either all the charges or some of the charges. It is then for the state to decide what to do about that, because the state as a responsible organ of state cannot be seen to carry on with a prosecution in the face of an order that's an unfair trial. And the state must then exercise its powers in terms of Section 6. It's not for the court to order them. The state must do the responsible thing. And if the state wants to appeal it and take on, ultimately, and if they're unsuccessful, they will come back to the same point. I don't think that the court has the court can order just an equitable relief. And it's a debate. Is just an equitable relief to order the state to stop the prosecution? Or is it just an equitable relief to say the trial will be unfair if you proceed against Thales? Then the state must, as the responsible organ of state, decide what to do. And of course it is then academic that you cannot in the face of such an order proceed. I'm not going into all the case on what's just an equitable. I believe this court has dealt with it many times.
Yes.
It's as simple as that.
And the way I understand it, you say 342A is not the route to go.
No, my Lord, we cannot. And we dealt with that in the heads of argument. It does not provide for jurisdiction to do what we ask you to do. It provides for a postponement of the case and cost orders. If I may read it, just find it in my heads where I deal with that. That's simply an unreasonable.
Proceed, there's a gentleman who's taking a photo of me at the back. Can you please stop doing that? Can you see to it that doesn't happen? I don't know what they're going to do with my photo.
My Lord, that's page 26 of the heads, paragraph 74. Yeah. And if I may ask you to turn to page 27, that's the relief in section 342A3. That's refusing a further postponement. That's Granting a postponement subject to conditions. It's not there. An order as to the payment of wasted costs. An order the matter be referred to the appropriate for administrative investigation and possible disciplinary action against the person responsible for the delay. And 42.5 does not work as well. It says, only in circumstances where the accused has pleaded to the charge and the state is unable to proceed or refuses to proceed with the case, the court may grant an order that the proceedings be continued. That's the typical case where the state comes to a standstill in the state's case and they refuse to close their case. Then the court will say, then I close the case on behalf of the state. That's that power that the court has. But this is not a case where the state is unable to proceed. It can proceed on their basis. So 3420 is wholly inapplicable, Manor.
Yes.
Thank you, Manor.
Yes, thank you. Do we take a comfort break before we proceed, Mr.
Yes, but this is my last.
Yes, we'll take a comfort break for 15 minutes.
Yes, but please.
Yes, Mr. Rowe.
The revision of the court, I just left out the last very short submission.
You want the second bite of whichever?
Not a second bite, it's half a bite. My Lord, and the reference in the Botma case, if you want to make a note, my Lord, is paragraph 75.
Yes.
And what it deals with in paragraph 75 of the judgment is the case where you have this irretrievable weakening of a defense.
Yeah.
Where, and it says, witnesses die, evidence disappears, memory fades. These factors, the natural products of delay, may not necessarily be sufficient to establish unfairness. If, as a result of the lack of evidence, the judicial officer dealing with the matter is unable to make a clear determination of guilt, then a presumption of innocence will ensure an acquittal. That is in a case, that's not the case where the court found there was an insurmountable trial prejudice.
Yeah.
And what we say in this case, it doesn't help where Carlos is paralyzed to say, well, go to trial, you get the benefit of the doubt, you have the presumption of innocence, and therefore you will be acquitted. So we offer you a wheelchair, but you will still be paralyzed. It's not helping. Thank you, my Lord.
Thank you. Yes, Mr. Mpofu.
Thank you, my Lord. This is what we propose to do, my Lord. I'm just going to give a quick outline, and then I will, my learned friend, Mr. Buthelezi, will deal with a specific topic for about 15 minutes, and I'll ask the court to stop him if he goes beyond.
Yes. I'll time it. Don't worry.
I'm indebted to your Lordship. Then, my Lord, I will then come back to those points. But I just want to give an outline also to contextualize the submissions that are going to be made by Mr. Buthelezi. My Lord, we are going to approach the matter from a slightly different angle. But as your Lordship knows that in the main we support and are of the view that the TALIS application should succeed in any event, even if whether we're here or not here. But we will emphasize, my Lord, that the matter is really can be decided on the very first point, which is that the state has materially misconstrued the case that is being brought by both accused. To the extent, my Lord, and this is not an exaggeration, that the real case between the parties has not been answered. And we will, and it remains basically unopposed, simply because of just a misreading of what the case is about, and we'll demonstrate that. That's number one. Number two, we'll very briefly, almost in the same breath, deal with the points in limine that have been raised to show that they are meritless. Number three, my Lord, we will deal with the so-called Stalingrad scratched record or old song that the state is singing yet again to show that A, it's irrelevant in this particular case, because this case is not about delay. That obviously flows from the misconstrual of the case. And B, that in any event, even if it was relevant, that theory is based on half-truths, misrepresentations, and even blatant lies or falsities. Then number four, my Lord, and this is basically at the heart of our intervention here. We will demonstrate that the cases, for the purposes of section 35, 3I, which is what the case is all about, the position of the two accused is inseparable.
Just a moment, please.
Thank you, my lord.
Yes.
In other words, as you know, my lord, that we call ours a conditional counter application. So it's conditional on the success of the case of Thales. And we're saying if that case is successful, there's no scenario in which then Thales can be acquitted, but the other accused stays. And that leads us to the last point, my lord, which is what Mr. Malenet Jr., Mr. Buthelezi will address you on. And that is that these witnesses who are unfortunately dead are central, and on that we're at one with Thales, that they're central to the case, and as Mr. Roux has already pointed out, they are central to the key question in this matter is the so-called encrypted facts. Quite frankly, without the encrypted facts, the whole thing just disappears, and Mr. Buthelezi will demonstrate the nature of the charges themselves, as well as the centrality, I think that's the correct word, centrality of the witnesses, centrality of the encrypted facts, and particularly in relation to the fact that this thing is based on common purpose anyway, which Mr. Roux has covered. So those are the 5 themes, my lord. And although it's out of place, I'll beg the leave of the court that Mr. Buthelezi then starts with that topic of analyzing the charges and showing how interrelated they are. And then I'll come back and deal with the other 4 topics. As God pleases.
Mr. Buthelezi, 15 minutes start now.
As the court pleases, thank you, madam.
Well, thank you, my lord. Where we find ourselves currently, there's a situation in normal cases where the NPA would have to decline to prosecute by virtue of the fact that they don't have a winnable case. Often the public is disappointed when they've laid complaints, criminal complaints of this nature, but the NPA declines to prosecute by virtue of the fact that they don't have a winnable case. And what we seek to demonstrate for you now is that on the constitutional point of section 353I, the state no longer has a winnable case. And the state, for all intents and purposes, wants to run a trial of the deceased when you take into account that essential witnesses like Tetard, Moino, Mr. Leek, 3 of whom are the only people who can say today to this court that this is the facts that is alleged to have been the foundation of this criminal enterprise that these guys seek to allege. Now, the state wants to bring us to a trial where nobody's ever seen this fact anymore. And their way of doing that is want to rely on what was said in the State versus Sheikh matter, but we'll get to that. Now, that's the first point. And all of this now, as I earlier stated, my lord, must be anchored in the understanding of section 35.3I, not section 35.3D, as the state wrongly persists that this case is about 35.3D. The papers tell them explicitly so. We've told them explicitly so. They persist with this wrong assertion. And I expect that they will try again today to come tell Thales that they've said their case is 35.3D, and Mr. Roux said it explicitly well today. He said our case is not 35.3D, our case is 35.3I. And what 35.3I requires us to do is to adduce evidence and to challenge evidence. Now, what does adducing and challenging evidence require of us? It requires these 2 components. One, we need to be able to challenge the allegations against us that we were part of a criminal enterprise. Now, that's the first point. Now, 2, we need to be able to challenge the state's witnesses. Now, if we have been brought to trial, handcuffed, in inverted commas, and literally literally bound at the mouth in as far as being able to challenge these essential allegations that they want to make against us. Now, the third introductory point is to make is that at the start of this case, when this matter was brought to court, the state made an election. And the state made this election. The state made an election to say they're bringing a case of racketeering. Okay? Mr. Roux started with this point in saying this, which is what the essential thrust of my submission is. The state made an election to say there's a case of racketeering here, upon which we plug every other charge on this racketeering charge. And that's why we've got two accused. Because these two accused here symbolize the fact that the state is of the view that we had common purpose. Now, already you know from the state versus shape matter, and here, and the case pleaded by Thales, they deny this common purpose. Well, today without a witness. We deny this common purpose, but we can't challenge them in that evidence. So let's now look at what these charges look like. First, we need to disabuse this court and the public and everybody else of this allegation that there's 783 charges of corruption. There's no such nonsense. It's never been. We only have 18 counts. Okay? And I'll break down these counts for you, my lord, so that we understand. It's count one, a charge of racketeering. If you read the indictment is premised on 4 paragraphs of racketeering, which include the structure of the racketeering, the enterprise, if I may, my lord, just simplify it. Sorry, my device had to switch off. But I have my, so this whole case couldn't have been built any other way, anyway. Because the only way they could say, this chapter 3 of the indictment, and it says count 1. Chapter 3 of the indictment talks about racketeering. A, the offenses of racketeering in general. B, then the indictment goes into what this enterprise of racketeering was about. 3, they then go into the objects and the methods of the enterprise. And 4, they talk about the persons and the entities that entail this racketeering charge. And the acts of racketeering, then they count and they list all the acts of racketeering. Then when they finish that, then they go to the remainder of the charges, which I'll get to. Now, here's the point. Where does this concept of racketeering come from? The concept of racketeering comes from where the states wanted to be able to prosecute organized crime, where your conduct, not by a singular event, by a cumulative series of events. If, let's say, for example, it was a human trafficking exercise, the person who identifies the people to be trafficked, the guy who drives them to the border, the guy who conceals them, the guy who hides the money, the guys who do all of that entire enterprise is called racketeering. And this is the case that we've come to meet on behalf of Mr. Zuma. And they've constructed this entire whole theory of 783 payments that constitute racketeering. Where do these payments come from? They are alleged to have come from Thales via Mr. Sheikh. Therefore, the directors of Thales are responsible for establishing that, yes, indeed, or this court must prove that you can't deny that you guys made payments to Mr. Sheikh as part of this racketeering enterprise. Now let's look at it. Now count 1 is the actual charge of racketeering. Count 2 is a charge of corruption. However, it is based on the charge of racketeering. Count 3 is a charge of corruption against Thales. Doesn't apply to us, but it also links to racketeering. Count 4 is a charge of corruption against Mr. Zuma only. Is a charge of corruption against Mr. Zuma that is only linked, that talks to racketeering. Count 5 is a duplication of charge 4 against Thales and against this entire enterprise. And number 6, charge 6 is a charge of money laundering based on the same facts that allege racketeering. Therefore, what do you find? You find that if you can prove this racketeering as one singular charge, charge 1, then you automatically get through by ticking the boxes that go from charge 2 to charge 6. The inverse is also true. If you disprove racketeering, charges 2 to 6 fall off automatically, because those 2, 3, 4, 5, 6 charges cannot stand in the absence of the racketeering charge. And that's the election that the state has made. And we must hold them to that election. Now, charges 7 to 9, to clarify the matter. Charges 7 to 9 allege that Mr. Zuma made representations to Parliament in the registrar of members' interest for not declaring monies that he had received as part of this racketeering enterprise. Okay, we accept that. Now, charges 10 to 18, what are those? Those charges are 8 charges that allege that Mr. Zuma did not disclose to SARS monies that he had received as part of this criminal enterprise. Where does that leave you? Clearly in the position that, 1, if you disprove or are unable to prove the criminal enterprise, you cannot prove charges 2 to 17 or to 18, all of them. The entire case collapses. This is where now this point about this case is unwinnable now comes in. Second, now where does this entire criminal enterprise come from? It comes from this allegation that there was once a Mr. Tetard who wrote a fax saying that we had a meeting and in this meeting we agreed A, B, C, D. Okay, that is the encrypted fax. If, as was contested in the Sheikh matter, Mr. Tetard disavows that fax, says no, the affidavit I gave you where I admitted to that fact was procured from me by then Minister of Justice Maduna and NDPP Mr. Nuga when they flew to France. A most situation that we have to test. And then after their meeting, he wrote and changed his evidence. Here's the point fundamentally as it pertains to section 35.3i. We need to put that version through to Mr. Tetard and say, Mr. Tetard, what were the circumstances in which you, 1, wrote this affidavit, and 2, then wrote an affidavit disavowing it? Number 1. Number 2, we have to put a version to Mr. Tetard that says, Mr. Tetard, did you not write that fax? And if you did, what did you mean? Mr. Tetard is not here. And he can no longer be here. And the distortion that the state wants to make is based on what was said in the permanent stay application, where the state, Mr. Rule, traversed this point quite gently. They said, oh, we'll cross that bridge when we come to it. You're saying he's got Alzheimer's. He says, no, we'll deal with that at the trial. Guess what? We are now at the trial, and Mr. Tetard is deceased. Now, that point is no longer moot. That point is a real point. So, if we are asked to go to a trial where we can no longer challenge these allegations of a criminal enterprise, of being party to a criminal enterprise, what are we being asked to do at this trial? Is that not an unconstitutional trial ab initio? Our submission is that it is. Now, that's the first point. Now, all of these points, so that I can be brief, my lord, I will not, they are contained in our heads, but fundamentally the point is that we've highlighted what the indictment alleges against us as being common purpose. And there is no running away from common purpose for the state. The common purpose is a simple point, that Thales acted with Mr. Zuma in pursuit of whatever illegalities that they allege. If we can no longer be challenged by Thales to say, hold on, we are supposedly your co-conspirators in this issue, what do you say? Mr. Zuma turns around and says, oh no, I don't know, I wasn't there. And this is a point that matters fundamentally. One of the hypotheses that was advanced in the Sheikh trial was this one. In the Sheikh trial, one of the points that was pushed was that possibly Mr. Sheikh may have been purporting to act for Mr. Zuma without Mr. Zuma being aware. and this point comes to this one, because there's no evidence in the Sheikh trial, in the charge sheet, in any of the evidence where Mr. Zuma is found to have said to targets, yes, please do APC. Nowhere. It is not said in the Squire's judgment, it's nowhere. And this is the crux upon which we need to defend ourselves. Where another issue that transpired in the Squire's judgment, if you read it, is the fact that this alleged bribe was, as a matter of fact, never paid. And is a contentious issue in the trial where the judge even goes to say the reasons why this alleged bribe was never paid will never be known. We need Tetard and to come explain the circumstances, because their the version advanced there was to say no, this wasn't a bribe, it was something, supposedly a donation that was never paid because there was a misunderstanding. And the state persisted with one version, and this issue was never resolved. We are coming to a trial where we can no longer test these propositions. Now, if you read the Squire's judgment, we have counted up to 50, if not more, versions, propositions, and issues that we need to dispute through viva voce evidence, not on what the state wants to do and say we want to import documents that were admitted in the Sheikh trial, have them admitted as hearsay evidence, documents which now carry zero probative value in as far as we need to test that evidence. Now, we did an analysis, but we can't read all 50 versions. But, my Lord, if you may allow me, I need to read these, a paragraph to page 213, because this is from SACR, State versus Sheikh and others, is South African Criminal Law Report. So it doesn't have the SAFLI ease of reference. If I may give your Lordship the real citation, S versus Sheikh and others, 2007, 1, SACR 142D. And the point is a simple one. And I need to quote this at page 213. It says, the evidential foundation of the main charge is the handwritten draft, which is the encrypted facts, or the practical purposes, the agreed translation into English, which are exhibits E25 to 26 and to E30, respectively. It is not disputed that exhibits 25 and 26 was written by Tetard. Know that he and Sheikh were directors at the time Thompson CSF Pty Ltd, as an accused number 11 was then called. Nor was it disputed that the plain and obvious meaning of the facts is that the proposed arrangements discussed between at the two previous meetings by Sheikh and Tetard on 30 September 1999 and in Durban by Tetard and Pierre on 10 November 1999 and in Paris, respectively, was confirmed by a third meeting in Durban on 11 March 2000 of Sheikh, Tetard, and Mr. Jacob Zuma, and agreement reached about the proposal. Now, this is the issue. We are prosecuted today by virtue of this allegation, in fact. How do we go to a trial where we can no longer challenge this? And they want to bring this judgment as the basis upon which we are to challenge that. Now, the point at section 35.3i is this and this only. If we are unable to adduce and challenge evidence, and that situation is manifest and evident right now, this court can no longer say to us, we are guaranteed a free trial, a free and fair trial. It cannot be. So, what the state wants to do, and this must be said, the state now runs this case knowing that they can't win it. However, they run it to save face, because they've run a 20-year plus trial pursuing allegations of corruption of 3 million rands of change at hundreds of millions of cost to the state. Now, having done this thing against the public, of spending hundreds of millions to chase an allegation of 20 years ago that is about 3 million rand. They can't just walk away. So now they're forcing your lordship to be in this position of where you sit over a dad of a child, as if this court doesn't have a role that's busy enough with real matters. We say to your lordship in conclusion this point. 1, Section 35(3)(I) requires that this court guarantees us the right to adduce and challenge evidence. The facts that sit before your lordship point in time demonstrate that is no longer possible for us. It is no longer possible for time. 2, that failure to guarantee this right on these essential elements, because the state made the election to bring a case of racketeering. The case of racketeering on their own indictment, their own indictment of us, is premised on the fact that there was a criminal enterprise reduced to paper. That paper was a letter written in French, subsequently translated, and somebody put it down. The point is this point. That evidence can no longer be tested in this trial. If that evidence can no longer be tested in this trial, then there can no longer be a free and fair trial. Thank you,
Thank you, my lord.
Just a moment, please.
Oh, yes, God, please, my lord. Thank you, my lord. My lord, before I come to my 4 points, let me just round off the issue that Mr. Buthelezi has dealt with, and we'll also deal with it obviously in reply, depending on what the retort is. Subject to what my learned friends are going to say in response, we must then proceed from the basis that Mr. Buthelezi's analysis of the charges are such that without these 2 witnesses who are now deceased, that case cannot be sustained by the state. Now, bearing in mind where the onus lies, these are criminal proceedings. Bearing in mind the presumption of innocence, if the state is unable even to assert its case, forget about the responses of Mr. Zuma and Talless and so on, then what are we doing here? And why there's this absurd notion that says, no, this must be determined by the trial judge. Well, that's just from the cases. Your Lordship, you are the trial judge. There's another misconception about that the trial is going to commence at some stage when we call witnesses. No. The trial commenced on the 26th of May when the 2 accused pleaded. But to round off Mr. Buthelezi's point, my lord, let me take your lordship to the so-called encrypted facts, which you'll find in the state's head of argument against the second accused paragraph. It's at various places, but you'll find it at paragraph 3. Page 11. I'll paraphrase, my lord, to save time. Yeah. So the essence of the so-called encrypted facts, which is at the center of this case, is this. When it's translated into English, it was written in French. It says, following an interview on the 30th of September 1999, Mr. Sheikh and my conversation with Mr. Pereira in Paris, I've been able to meet JZ in Durban on the 11th of this morning during a private interview in the presence of SS. SS has been explained as Shepherd Sheikh. I asked at least for clear confirmation, and then Mr. Zuma encoded, in an encoded form, then confirmed whatever he confirmed to Mr. Tetat, one of the people who are dead. Let's just stop there. Let's assume, I'm making this up, Melo. Assume that this coded form was, look, if I say, is the weather clear, then you are confirming the bride, so-called bride, yeah. And that's what then said Mr. Tetat says, is the weather clear? Other one says yes. Now, all of that how is it ever going to be proved in the absence of Mr. Tetan, who is the decoder of the so-called code? How? And then, of course, it says that the quid pro quo was protection of CSF during the current investigation and permanent support of JZ in future projects, whatever that is. I mean, the second one, you can kick it away. So it's supposed to be protection during current investigations. What does that mean? What does it really mean? Mr. Tetad, who's the one who put this quid pro quo, should tell the court, and then the state will say, no, from that evidence, my lord, you must read this, that, and the other. And that's it. So let's then go back to really the nub of this case, my lord. I'm saying this really in all humility. It's very disturbing, to say the least, my lord, that the state does not seem to understand a simple case. Your lordship said in the morning, in tongue-in-cheek, that to Mr. Rui, this is a straightforward case, and your lordship was correct. But the state, the NPA, has completely answered a different case and left the case that has been pleaded by both accused untouched. It's perplexing, because the job of the NPA is to understand two things in their entire life: Section 35 of the Constitution and the Criminal Procedure Act. If they don't understand those two things, well, I don't know what else I can forgive them for not understanding the res judicata rule and applying it in criminal proceedings and all that. But not to understand Section 35 and the Criminal Procedure Act is unforgivable. This case, my lord, is based on Section 35(3)(I). But your lordship will see these bundles and bundles of replying affidavits. All they boil down to is that the state is answering a case based on Section 35(3)(D) about delay-induced trial prejudice. That's what they say. Now let me explain one thing, because I can anticipate what they're going to say. It is true, my lord, that the issue of the delay is, if you talk about the factual sequence, you can refer to it. It's like pointing the obvious. Well, if the trial had started in 2010, that would have been before Mr. Teta died. But so what? It didn't start then. He's now dead. So that's the only tangential application of the so-called delay rule. And that means, my lord, and this is where we part ways a little bit even with Mr. Ru's approach. That means that both 35(3)(D) and 342A, remember, my lord, 342A is just a statutory manifestation of the delay rule. Both of those are irrelevant in this case, because the assertion that is made, at least by accused number one, is not that there was a delay and all that. It simply says, as matters stand now, our right to adduce and challenge evidence is infringed. Full stop. And the question is, whether is it infringed or is it not infringed? So even this whole story about delays and Stalingrad and what is completely irrelevant. And I'll demonstrate it like this, my lord. Assume for a minute there's Stalingrad, there's all these things. The question is, as we speak now, is there going to be a fair trial or no for a fair trial? Right? So it's not our law that if that situation is caused by you, the so-called author of your own misfortune and all that, it doesn't feature anywhere. So it doesn't matter whether the delay was caused by Thales, by Mr. Zuma, or by the state. Your lordship knows the stories about each one points a finger to this one. No, you caused the delay, you caused the delay. It doesn't matter. The question is the concrete situation. So the state relies on these cases of Sanderson, even Botma versus else. All those cases are about delay. They're not about what we're about here today. Mr. Roux correctly summarized the case in Botma versus else, which was about the 37-year delay of a sexual harassment or a sexual assault case. Sanderson is the locus classicus on section 342. But with the greatest respect, all that is interesting law, but it has nothing to do with what we're about here today. Now, your Lordship will find, I'll just give you, your Lordship, maybe one or two examples. This is what they say. You'll see this in our heads at paragraph 8, my Lord. We say at 8.1, this is the state's misdirection and misconstruing of the second accused case is glaring in that it says the following. The state's second preliminary point is that the substance of the relief Thales is seeking in the present application is the same as the permanent stay prosecution it sought in November 2018. That is, its prosecution of the charge in the indictment to be stopped. It follows, I submit, in order to succeed, Thales has to establish that due to delay-induced unavailability of evidence, there is no way in which it can have a fair trial on the charges against it. That expression is taken directly from Botma versus Else. But we, at least ourselves, we're not talking about delay, and you'll find there are references many. In paragraph 9, there's another one. I respectfully submit by now invoking the unavailability to testify due to their passing many years into the delay for which he has largely been responsible as the basis for seeking the setting aside his prosecution. Mr. Zuma is approaching this court with unclean hands, and for that reason alone, his conditional application should be dismissed. There's no such thing as unclean hands. It's ridiculous. This is a constitutional case, my lord. The best example to show that the so-called doctrine of unclean hands cannot apply in the case of an infringement of constitutional rights is S versus Makwanyane, the well-known death sentence case, my lord. There, I think it was just Carlson P and Krichler J who made this point. The other judges made it too. That the rights in the Constitution, my lord, are there to protect even the worst among us, right? Because those are human rights. So it doesn't matter. So for example, the protection against the death sentence can only happen if you've murdered someone. So you're already a murderer. So we can't say, no, because you are a murderer, if you hadn't murdered the person, you wouldn't be in this situation in the first place where you need to be saved from the death sentence. That's the argument that the state is really saying. Because they're saying, well, if you hadn't delayed the case, if you hadn't done this, this situation you find yourself now would not have happened. But it doesn't work like that. There's no doctrine of unclean hands when it comes to the pure question of whether a constitutional provision has been violated, limited, or infringed. So that's the first set. The second thing, my lord, to do with the myopic conflation of 35D and 35I is this. Your lordship knows, and I think Mr. Roux referred to this in the morning. You know, your lordship, that in terms of the delay rule, the seriousness of the crime plays a role. In the sense that the court says, well, there might have been a delay of 5 years, but hey, you killed 100 people. Therefore, we'll err on the side of letting the trial to continue for the obvious reasons society needs to assuage and all that. Here's the thing, my lord. When it comes to 35.3I, the seriousness of the crime actually favors the accused. So that's one of the fundamental differences between 35D and 35I. Because, my lord, it's obvious that the more serious the crime, and the more you're unable to cross-examine those who accuse you, then you should be, because of the presumption of innocence and all those things, you can't be then subjected to that trial. If it was a traffic offense, you might say, okay, well, maybe the traffic cop is not here now, but here's the ticket. Let's just get on with it. But not for a serious offense, where you're unable to cross-examine the very people who are implicating you. Yes. So that's that's why this thing about misconceiving 35D and 35I is not a mere technicality. It's not. It's a major off-ramp, off a tangent that takes the state nowhere. Now, my Lord, we therefore submit with the greatest respect that once the state does not answer the nub of the case presented to it, then surely they cannot succeed in their defense. And my Lord, the approach we take ourselves as the first accused is summarized very succinctly in our heads. Sorry, my Lord. All right, I'll get the passage now, my Lord. But in a nutshell, we say the following, my Lord. The case is very simple. It says, Your Lordship must first declare whether or not Section 35(3)I has been violated by this current circumstances. If Your Lordship agrees, which there is no other conclusion, that section has been at least prima facie violated, let me put it that way, then Your Lordship has two duties. One is to find out if there's a Section 36 justification. Your Lordship knows the law around that. So this is how our law works, not on these things of unclean hands or whatever. If there's a prima facie violation of a constitutional right, then you can only justify it in terms of Section 36. If you can't, then it must be declared. Then if that happens, my Lord, then Your Lordship must then give just and equitable remedy following from that declarator. That's all. My learned friends for Thales put it slightly differently, but it comes to the same thing. They say it's Section 38, but it's the same. For the purposes of this argument, it's the same. But Section 38 says if you violate a right or threaten to violate a right, you can get a declaration and then you get appropriate relief. So it's the same thing, whether it's just and equitable or appropriate relief, doesn't matter. So that's all we have to do in front of Your Lordship, quite frankly. It's the first part. The second part follows automatically, is to convince Your Lordship that on these facts, the right to adduce evidence, that is now on behalf of Thales, and in our case, the right to challenge that evidence. Both of those rights are part of 35(3)I, has been at face value infringed. That's all. Then we sit down. Because if we establish that, then why should Your Lordship then say, well, let's go on for the next 2-3 years and have a trial and so on, when we know that now, today, on the 24th of April, those rights have been infringed. Now, this links, my Lord, to Section 166(1) of the CPA. And that's where you'll find the slight variation between us and Thales. So Thales says, we want to call Mr. Teta and Mr. Moino. So they want to adduce that evidence, right? And then they also say, we also want to cross-examine Ms. Delik. Yeah, Ms. Delik. That's the secretary. All of these persons are deceased. We say, in terms of 166(1), we have a right, as co-accused, to cross-examine Mr. Teta and Mr. Moino. Because Your Lordship knows it's right that in terms of 166(1), a co-accused has a right to cross-examine the witness of the other accused. So let's go back to Mr. Buthelezi. Mr. Buthelezi says, what if Mr. Teta denies everything? He says, me, I didn't write any encrypted facts. If he says that, then it will absolve the company, obviously. And we will probably not even ask him a question. So take the other side. What if he confirms? He says, yeah, the encrypted facts, yeah, it was me. And it was about a bribe. Then we have to cross-examine him to say, okay, well, where did you meet? Was Mr. Zuma there? And so on and so on. What was the code? And all that. We have a right to do that, a constitutional right. That right has been denied from us by the death of Mr. Teta. It's as simple as that. That cross-examination, whether it's going to be successful or unsuccessful, is irrelevant. It's the right to cross-examine in the first place that has now been taken away by his death. And that right, there is no trial, fair trial, that can continue when that right is no longer available to us. It's just impossible, particularly in a case of common purpose and conspiracy and all these things that have been alleged. Then, my Lord, if I may then move to the second topic, which is, let me quickly dispose of the so-called points in limine. Well, my Lord, I won't even spend 2 minutes on this. The points in limine are just completely meritless. The first one is this thing about you are the author of your own misfortune. I've already addressed that. It says, well, you if you hadn't delayed, then we wouldn't be where we are now. I'll deal with that when I deal with the so-called Stalingrad thing. It's not part of our law. The second one is really linked to my first point. Because they say really, in reality, these applications we bring are res judicata. Now, they can only be res judicata if they are right that this case is the same as the stay, permanent stay case. And they can only be right, that can only be right if 35.3d is the same thing as 35.3i. If they are not, we all know the rules of res judicata. It must be the same cause of action. And our version is that these are different causes of action. So that's the end of the res judicata point. So that's the so-called points in limine out of the way. Then, my Lord, let me come to the third topic, which is the maybe before I do that, my Lord, let me hand up an unreported judgment that is cited in our heads. I beg leave to hand it up, my Lord. That case, my Lord, is a case, it's one of the cases that is referred to towards the end of our heads. The Lordship will see that there's a cluster of cases that are in paragraph 45 of our heads at page 23. And I'll deal with them all in one breath. They are S versus Mutlabane. The citations are there, my Lord. S versus Makena. S versus Msimango. And we say those cases are, all of those cases are conveniently referred to in S versus Kumalo. S versus Kumalo is the case I've just handed up, my Lord. And I'll read the relevant passages. This is just to demonstrate that if your Lordship will bear with me, I'm going to read quite a lot of issues, because all these cases are really referred to in this. If your Lordship goes to from paragraph 15 on page 8 of Khumalo. Is the Lordship there?
Yes.
Thank you, my Lord. You'll see there, my Lord, that the first reference is to McKenna. McKenna was a case in the Cape Division, and the submission we make there, my Lord, is that various divisions have dealt with this to the extent that this court ought to be persuaded. And one, Khumalo itself is 2 judges in the Gauteng Division. So they are, if not strictly speaking binding, they are at least highly persuasive. It says, the former Chief Justice of the Republic, as a puisne judge, said in McKenna, quote, the short answer to this submission is that the right to, quote, adduce and challenge evidence is not dependent upon the result. Very important. It is a right which is guaranteed by the Constitution, which must be complied with in all criminal trials. There is no place for the so-called no difference rule under our Constitution. Let me pause there. So there's no place for this defense that we are told here that, well, it makes no difference that these witnesses are not here. You can call Mr. Sheikh, you can do that, and I want to address Mr. Ru has correctly poo-pooed that idea. But, that in the first place, it's not part of our law. The right to challenge evidence, which is essential to a fair trial, can never be dependent upon the result. Courts should not speculate on what would have been the effect of challenging the evidence. So one of the defenses that you are told is that, well, we understand that Ms. Delik has died, but the state, these are their words, intends to apply at the trial for the hearsay rule to be removed. What is that? On what basis can the court now make a decision on the speculative basis that that application in terms of Section 3 will be successful? Your Lordship knows the law about this. And I make an example, a simple example. Your Lordship knows about the law in terms of appeals. That it is said that you can't say, if I'm late in submitting my application for leave to appeal, then I come to this court and I say, well, please, court, suspend the operation of the judgment. And the court says, on what basis? No, because I've put in a petition in the SCA, but it's late. I've also applied for condonation. The court says, no, you can't suspend this judgment on the speculative basis that you're going to get condonation. What if you don't get it? So it's that same principle. So the hearsay thing about Ms. Delik is just completely nonsensical on this authority. And then, my Lord, let's jump to. Oh yes, no, let's not jump, because this deals with this thing of prejudice, which is really also irrelevant. So this effectively puts paid to an argument that the courts should consider whether cross-examination has been substantially completed, or whether the prosecution can show that the accused has not been prejudiced. So then it says in Matlabane, this is what was said, my Lord. That one is in 95B. That would be the Botswana court. The death of a state witness during cross-examination, during the process of cross-examination, results in the failure of the accused to exercise his right to challenge sufficiently the evidence of the witness. That's where we are in this case. Use of untested evidence against the accused will result in the infringement of that right. Applying to the above in the present, I'm of the view that even though Mr. Janet Siyako had been extensively cross-examined before she died, it is difficult to predict what would have happened if such cross-examination had continued. Moreover, the witness had not been cross-examined on the question of identification. The accused's right to challenge her evidence has been adversely affected. Paraphrase, my Lord, this was a case which was better than this one. Ours is worse for the state. Because here the witness had been cross-examined and then she died in the middle. Here the witnesses have not even started. So it's and then here's the important thing, my lord, because as your lordship knows, it is said that your lordship should deal with this at a later stage. That the right to a fair trial encompasses fairness at every stage of the proceedings. In other words, even now after the pleading, the plea has been made. And the right includes the right to cross-examine witnesses. This right, in my view, includes the right to complete the cross-examination and so on. Then, my lord, the 21. Just looking for the quote that you'll find in our heads, my lord, which rounds up. 20. That's quite this, my lord. Yes, when I reading evidence. Oh, yes, that's in the Msimango case, yeah. And it says, I have come to the conclusion that no property value should be attached to the evidence of a witness who was absent for whatever reason, including illness or death. The passage I was looking for, my lord, is the one that's quoted in the heads. I'll just read it from the heads, paragraph 21. Because that really encompasses all these cases, Makena, Matlaban, and so on. And I'll read it very slowly because this is very important. It says, in cases where the accused's right to cross-examine a witness is curtailed, for whatever reason, in other words, it doesn't matter whether it's his fault or whatever and all those things, for whatever reason other than the accused's refusal or failure to cross-examine the witness of his own volition, there is an infringement on his right to a fair trial guaranteed by the Constitution. That's it. End of the case. Well, unless you can show that the curtailment of the right to cross-examination is by the accused's failure to cross-examine. I mean, the court can't force someone to cross-examine. We know that's what happened in the so-called Omotoso case. If issues are not raised in cross-examination, the state can't turn around and say, if the state had been stopped from cross-examination, then obviously that would be a different thing. But if they've been given the chance, but out of their own volition, they fail, that's a different matter. So the law is very clear, my lord, on the impact of 35(3)(I). Now let's go to their favorite topic, Stalingrad. Well, my lord, interestingly, one of the things that they don't say at all, well, in fact, they say the exact opposite. Oh, let me put it like this, my lord, first. Let's just indulge the state for a minute and say this was about so-called trial prejudice, whether it's related to delay or not delay. Then the court must then remember this, that the so-called delays, even if the case was actually based on 35(3)(D) or 342(A), the so-called delays which preceded the commencement of the trial are irrelevant. So even in that case, the delays that we would be talking about would be from the 26th of May 2021 until now, because that's when the trial started. That's why it's called trial-related prejudice. Now, it's common cause. Forget about the boxing match between the state and Mr. Zuma on the so-called Stalingrad thing. What is common cause is that Thales is not involved. Both parties agree. They box each other, but they agree that Thales was not involved in causing those delays. So, on that basis alone, Thales would have to succeed. Let's assume we were not part of this. Thales would have to succeed because you can't say to them, no, you can't succeed because you are part of this. Now, all we're saying in the conditional application, if that happens, if Thales succeeds, then the following scenario happens. In effect, you will have what you call a separation of trials. Even putting aside Mr. Buthelez's input about the interrelatedness and symbiotic relationship between the charges and all that. And that would mean that Mr. Zuma's case must start de novo, because that's what a separation of trials entails. That would mean we have to plead again and go back to section 106 and all those, go back to 26th of May 2021. Surely nobody wants that to happen. But the related point is the one that I've already made, my lord, that in any event, if Thales succeeds, then we'll be left stranded in conducting our own case now. And that's why, by the way, you have joint trials. This whole thing, in terms of the Criminal Procedure Act, where you have joint trials, is to make sure that where there is common purpose and all those things, the trial is done jointly. And you can't now then artificially unscramble the egg, so to speak. Now, with Stalingrad, my lord, I have two submissions. The first one is that it is mightily irrelevant in the 35(3)(I) case, and I've already stated that. The second is that if the case was based on 35(3)(D) and the delay-induced trial prejudice, as they call it, then one would make that determination. And it would, even then, sorry, my lord. Even in that event, there's a case called State versus Galinjebo. I'll find the passage, my lord. But in essence, Dutoy says the following, that even in cases where the accused is responsible for the delay, it does not affect the fairness or otherwise of the trial in these kinds of proceedings. But of course, if it's delay based, obviously the delay must be, the court has to inspect how the delay occurred. In that case, it was found that the accused had actually been responsible, even to the point of intimidating the witnesses and so on. But the court still made the general point that there's no rule that excludes. Sorry, my lord. This thing will be niggling on me if I don't find it. Yes. You'll find that, my lord, in 33-32D of the supplementary volume of Dutoy. Where after looking, this is the the Dalinjabo case, my lord, is 2016 bracket 1 SACR 329 SCA. And Dutoy's commentary after that says, a delay, even an aggravated delay caused by an accused person, does not deprive the accused of the right to challenge the fairness of the trial. Okay. And I've already explained why that is so, why it's a pure question of a violation of the right. Now, the point about Stalingrad is the following, and that passage shows how irrelevant it is. That's why I said assume that the allegations are true, but they have nothing to do with a case based on 35(3)(I). But more than that, my lord, as we have said before, the time has come to put this ghost of Stalingrad to bed. Because it doesn't matter how many times the courts have explained that even when there are delays, and even if they can be attributed to this one or that one, it doesn't detract from the constitutional rights of that person to exercise his rights. That has never deterred this state. It doesn't matter how many times this court, forget about other courts, this court has on three or four occasions said, no, you can't do that. But it has been raised in just before your lordship, it was raised in the Downer matter, it was raised in the application for leave to appeal. Of course, it was raised in section 106. It was raised in the recusal application before Judge Kuhn 4 times. And 4 times, either directly or indirectly, the court has said, no, that's not the case. Now, here's the thing, my lord, about Stalingrad. My learned friends have defined it as, they've given some definition. So let's work with their definition. Now, to show the lie of the Stalingrad theory, my lord, there are 2 things. One is, your lordship, they say your lordship is bound by a finding which was made by the SCA in an unrelated matter of a private prosecution. Now, here's the interesting thing. In that case, 2 or 3 years ago, the state argued that the Stalingrad delays had been 20 years, I think 19 to 20 years, right? In this case, they are now arguing that it's 17 years. So from 20 years, 2 years later, it has shrunk to 17. How can your lordship be bound by something like that? It's like if the SCA said this case is being heard in Durban, and later the other side says, which is correct, it's held in Maritzburg. Then say, no, but the higher court made the mistake and said it was held in Durban, therefore you are bound. That's not stare decisis, that's just an abuse. So, even on their own terms, my lord, this so-called theory is myopic and convoluted and built on misrepresentations. Let me give you another pointer, my lord. 2 of the features of the so-called Stalingrad thing are A, that it emanates from what was said by the late J. Kemp in 2007, right? And so let's start with that one. It's common cause now. You've been given the chronology, my lord. What you are not told, they just put that quotation. You are not told whether this was whether he was referring to delays by the state or delays by Mr. Zuma. All it says is that this, whatever this is like Stalingrad burning house to house. Okay? No context is given. But there's one objective fact now, my lord, that comes from the papers before you, which shows that apart from seeking to desecrate the memory of the late J. Kemp, it shows that he could not have been referring to what is now known as the so-called Stalingrad defense. Why? Because when he made those utterances, Mr. Zuma was not facing any trial. The trial had been struck off the roll in 2006 by Msemang J. It was only to be resuscitated, as your lordship knows, in 2017 or whatever, later, after the whole spy tape saga. So there is no objective way in which Mr. J. Kemp could have been referring to the evasion of a trial, because there was no trial. That case was about some Mauritius getting evidence in Mauritius or whatever, like the lordship knows. But the point is that the objective evidence shows that it could not have been referring to that. But here's the big one, my lord. It is now common cause from these papers that for the period 2009 to 2017, that's a period of say 8 to 9 years. Because your Lordship knows that eventually the charges were revived in 2018.
Yes.
So in that period of between 8 and 9 years, guess what was happening? So if your Lordship can just work with me here. So let's say they have 17 years now, right? From that, take the 4 years, that is 2021 to now. Take it out. So you're left with 13 years. Of that 13 years, 9 were about this. It was a case by the DA, Democratic Alliance, about the spy tapes, which was opposed by who? The NPA. Of course, Mr. Zuma joined in that case, but the principal respondent was the NPA. And then the NPA that continued that fight turns around and says, well, that 9 years was wasted by you because you supported us. What is that, my lord? That's the same as in this case. If in this case, imagine in this case, if Mr. Roo has brought an application, Mr. Zuma supports the application, and then Mr. Roo later says, no, you wasted the time because you supported us. That's exactly the same situation. It's bizarre. So, and I don't want to bore your Lordship with all the details, but if you break down this thing with factual, not this hype and media generated thing, and just look at the facts, you'll see that at the very least, 9 of those 13 years were wasted by the state. And yet, they come and blame it on us. So let's be generous and say of the remaining 4 years, what was us? Even that would be wrong, by the way, because that includes Judge Nicholson's case and so on, but let's just be generous. Then on what basis can the same state that has now that's responsible for the bulk of those delays, then your Lordship could say, okay, well, I don't need a calculator. You are both to blame. You are to blame for another portion, you are to blame for another portion. So it cancels out. So that the whole issue just flies, is also irrelevant for that reason, apart from the fact that legally speaking, it is irrelevant. My Lord, if I can round off with this point, my Lord, which also links up with Mr. Buthelez's section. And that is that the two cases...
In the 10 minutes that you have left.
No, that should be sufficient, my Lord. Or shall we say, we'll cross that bridge when we get to it. Thank you, my Lord. No, that should be sufficient, my Lord. The point is a simple one, my Lord. That the inseparability of the cases, and that will arise from an analysis of the court of the charges. And in fact, my Lord, I'm not going to belabor that point because we'll see what the state has to say about Mr. Buthelez's analysis, and then we'll deal with it in reply. Yes, let me just, my Lord, just go back to the issue about the Section 36 justification. So, my Lord, the Section 36 is you know, there are many cases, Makwanyane included, where there was a thorough discussion on Section 36. In other words, the court says, well, let's look at, in terms of the book by, it's called The Bill of Rights Handbook by Carey and Duval, 6th edition. It says, my lord, at page 151, limitation in terms of section 36 is a synonym for the infringement or perhaps justifiable infringement. A law that limits a right infringes that right. However, the infringement will not be unconstitutional if it takes place for a reason that is accepted as a justification for infringing rights in an open, democratic society based on human dignity, equality, and freedom. In other words, not all infringements of fundamental rights are unconstitutional. Where an infringement can be justified in accordance with the criteria in Section 36, it will be constitutionally valid. Now, what you paraphrase there, my lord, is that is the so-called two-stage theory. So the limitation must be established. And I don't think even my learned friends are going to argue that the right to cross-examine is not limited when the person you are going to cross-examine is dead. That just goes without saying. So the question is whether is there a justification, if you do a pure constitutional analysis, is there a justification in terms of Section 36, yes or no? If there is, well, then it's constitutional. If there isn't, it's unconstitutional. Now, in this case, no Section 36 justification has been pleaded at all. In fact, there's not even a mention of Section 36 by the other side. And then it says, and this shows the so-called, the absurdity of the so-called unclean hands or whatever in the context of limitation of rights. It says, it must be emphasized that the existence of a general limitation section does not mean that the rights in the Bill of Rights can be limited for any reason. It is not simply a question of determining whether the benefits of a limitation to others or to the public interest will outweigh the cost to the right holder. Very important. So you can't say, well, yes, your right has been limited, but the public interest or the victims and all those things that you deal with in 35(3)(d), for example, that doesn't feature here. So it says, if rights can be overridden simply on the basis that the general welfare will be served by the restriction, then there's a little purpose in the constitutional entrenchment of the rights. Again, this almost stating the obvious, which is that why would we have a Bill of Rights if you can say, well, you can have the right to dignity, but the general welfare requires that you must be discriminated against. You can have the right to equality, but the general welfare requires that you must be discriminated as a woman or whatever. It can never be. This means that the limitation must serve a purpose that most people would regard as compellingly important, but however important the purpose of the limitation, restriction on the rights will not be justifiable unless there's a good reason for thinking that the restriction would achieve the purpose it is designed to achieve, and that there's no other realistically available way in which the purpose can be achieved without restricting the rights. Again, I don't have to list the shopping list on Section 36. Your Lordship knows the nature of the right, the importance of the purpose, the nature of the extent of the limitation, and so on. So, the gist, my Lord, is this, if you cut all this up. In summary, your Lordship has to look at the case almost in a piecemeal fashion and say, are the rights of Thales to adduce evidence, have they been curtailed, yes or no? If the answer is yes, has there been a justification? If the answer is no, then the declarator must come. And then comes the obvious, just, and equitable remedy, which is that the trial must be terminated. Similarly, in our instance, your Lordship must ask the question, by the death of these witnesses, given what Mr. Buthelezi has said, have our rights to challenge the evidence now been limited, infringed, violated, which the book says those are synonyms? Yes or no? Tick. If they are, has there been a section that says justification? If there isn't, then we go to the remedy. And the remedy, my lord, is very, very simple. The remedy is that the infringement of those rights means that there will be no purpose in continuing with the trial. And it's not so much a matter of course, it can be framed the way our learned friends have framed it as Section 6 of the CPA. But you don't even need to go that far, my lord. You simply have to deal with the constitutional violation, either in terms of Section 38 or 172, 1A, and then 1B. And that's the end of it. And the otherwise, my lord, what the state is really asking your lordship to do is to speculate about some possibility of, I mean, they even say, this is the biggest irony, and this is the last example I'm going to make. Remember, they say Mr. van der Walt also died. So there are 4 people who actually died in this case. Mr. Moynor, Mr. Tetar, Mr. van der Walt, and Ms. De Leek. All of them are crucial witnesses. So here's the irony. They say in the case of Mr. van der Walt, we are going to call the person who was a co-author of his forensic report. Well and good. Well, how does that assist us? Because surely what we want to do is to say to Mr. van der Walt, well, you said this in the Sheikh trial. What do you say now? And so on and so on. The so-called co-author, how is he or she going to be responsible for what Mr. van der Walt's contradictions might or might not have been in the Sheikh trial? Your lordship knows, any practitioner knows that there's nothing better for a cross-examiner than having a transcript of the same witness in the same proceedings. But here's the irony. So let's say that's the answer for Mr. van der Walt, that you'll call the co-author. What's the answer for Mr. Tetar? Where's the co-author of the encrypted facts? They don't even attempt to have that. So it's a hopeless situation, my lord, and there is no. It's an irredeemable. Even if we were to use the test in Botma versus else, which I say is not applicable, because this is not a case about delay, of an irredeemable trial prejudice. Even if we were to use that to adopt that test, we would pass it. But let alone here where it is not applicable. So, my lord, we would respectfully submit that on all those grounds, the relief sought by Thales ought to be granted, and conditional upon that, then because of the nature of the specific facts and the charges and the witnesses concerned, automatically the same should happen to the case of Mr. Zuma. As purposes, if there's anything else, my lord, we'll deal with them in black. As purposes.
Thank you.
If I may just I'm indebted to it.
Yes, we'll stand adjourned until 2 o'clock.
As God please.
Para James.
All right, please.
The Shake trial are available to testify for the state. There are 4 exceptions. They include Mr. Leek and Mr. van der Walt. The other 2 are a Mr. Yusuf Surti, who as far as the state knows died in December 2018, and Mr. Gavin Woods. What the Shake Trial Court made of the evidence of the people on the state's list of witnesses. But I do need to add something in connection with Mr. Leek and Mr. van der Walt, because they have passed, and because their passing has been specifically raised by Thales in support of its application. It's the second string to its bow. In its answer, the state has said that as regards Mr. Leek, at the trial, it intends applying in terms of a number of alternative statutory and common law rules for the admission of the transcript of her evidence given at the Shake trial. She was obviously cross-examined there, so it'll be the entire transcript. But that, of course, is hearsay evidence at common law. And it will also be applying for the admission of the so-called encrypted facts. And the alternative bases are set out in footnote 90 on page 36 of the state's heads in the Thales application. Now, Thales has indicated in its replying affidavit at paragraph 57, record page 663, that it intends to oppose the state's application for the admission of that hearsay evidence in the criminal matter.
Just a moment, please.
And in our respectful submission,
So just a moment, please, Mr.
I
President.
apologize.
Yes, Mr. President.
In our respectful submission, that is a dispute for another day. It's a dispute which will arise for determination when the state makes the application for the admission of that hearsay evidence. And as authority for that proposition, we respectfully refer you to the following remark by the Constitutional Court in the case of Savoy. That case is number 17 in our bundle, and paragraph 49 as well as footnote 74 are relevant. Paragraph 49 in particular, it's at the one at page 374. And there the court said, needless to say, it would be ill-advised to attempt to anticipate instances where the admission of hearsay would be so unfair as to infringe an accused's right to a fair trial. That is something best left to the trial court. And although you are the assigned trial judge in this matter, at the moment the adducing of evidence hasn't started. References to a trial court in judgments like that are apposite with respect. As regards Mr. van der Walt, the state has indicated that, and this is again in its of no doubt that the accused will raise an infringement of Section 35(3)(I) in opposition to any application by the state to have the hearsay evidence, in other words, the transcript of Mr. Leake's testimony and the encrypted facts admitted in evidence. And they're quite entitled to do that. Indeed, it is the obvious, with respect, basis upon which such an application would be opposed. Now, all that we wish to add in that is that the state accepts that the trial court has to rule on the application for the admission of that hearsay evidence and any other which the state may seek to adduce at the latest before the state closes its case. That was held by the SCA in the well-known Ndlovu case. That's number 16 in the state's bundle at paragraph 18, page 369. And that was quoted with approval by the Constitutional Court in the case of Molimi, M-O-L-I-M-I, at para 36. That's in the state's bundle number 15 at pages 346 to 347. But what we would do is just make the following point, my lord. All of this related to things which are down the track if this case is permitted to continue. And it's this. If, as things turn out at the trial, the hearsay evidence to which I've just referred is duly admitted, then contrary to what Mr. Zuma has submitted in his replying affidavit, paragraphs 34 to 35, that's at record 925 to 926, that outcome, in other words, the admission of the hearsay evidence after hearing argument from both sides and considering all of the factors listed in section 3.3 C of the Act 45 of 1988, if that is the basis on which it's admitted, that outcome will not constitute an unjustified infringement of the right to challenge evidence in section 35(3)(I) of the Constitution. And that is stated by the Constitutional Court in the case of KAPA, K-A-P-A, at paragraph 101. It's in the state's bundle number 7, and the relevant paragraphs at page 107. And again, that was approving Ndlovu in the SCA, this time paragraph 24, which is at page 360 of the state's bundle. So much for the manner in which the state intends dealing with the deaths of these two individuals, Mr. Leek and Mr. van der Walt. That brings me to the elephant in the room, the deaths of Messrs. Tetard and Moineau, which I think it's fair to say is the mainstay of Thales's, or the mainstays of Thales's application. And Thales's contention is really quite far-reaching. I've referred you to paragraph 113.1 of the state's answer, which summarizes the case. Their references are there given. And what one will see from those references, and particularly the portions quoted there, my lord, is the following. Thales alleges, firstly, that the two deceased officials were the only individuals who would have been able to testify on its behalf in relation to the charges against it. And you heard that submission made this morning. My learned friend, Mr. Roux, contended that following their deaths, Thales was paralyzed from the neck down, I heard him understand. In other words, it couldn't move its arms and legs to defend itself. And the sense that he was conveying is that it can't challenge any of the state's allegations, and it cannot call any witnesses to defend himself. That is the case that has been laid before you for decision. And that requires a somewhat closer examination of the situation in connection with Mr. Tetard, Mr. Moineau, and then whether there aren't any other witnesses from whom Thales can take instructions and or call should they go on their defense. So starting with Mr. Tetard, what is conspicuous by its absence is any answer by Thales to the point taken by the state in its answer in the present matter, that in the 2018 permanent stay, Thales alleged that Mr. Tetard was not prepared to assist Thales in any way. He wasn't prepared to return to South Africa, and he wasn't prepared to testify in South Africa or any other forum should a trial take place. And you will see that mentioned in paragraph 136.1 of the state's answer in the Thales application at page 119. And it is in the referenced paragraph, the state refers to the fact that in that 2018 application, Thales put up an affidavit by Mr. Tetard, which is dated the 11th of March 2009. The copy is Annex AA10 to the state's answer at pages 576 to 594, in which he said, amongst other things, he wasn't prepared to testify, and I quote, in any forum under any circumstances should a trial in this matter take place, unquote. And that one sees at paragraph 49 of that affidavit by Mr. Tetard at page 592. So that was the case which Thales took to the full court as to say why they were now in a bind, because Mr. Tetard, the central figure, was not available to them. He, of course, is overseas at that stage. In its founding affidavit, Thales doesn't explain when and why Mr. Tetard's attitude, this is now on Thales' version, changed in the period between November 2018 and his death on the 5th of September 2022, if indeed that is what happened. And nowhere in its replying affidavit does it explain when and why Mr. Tetard's attitude to testifying changed in that period.
Just a moment, please. Yeah.
And we consequently submit that your Lordship can safely proceed on the basis, and this is on Thales' version, that Mr. Tetard remained unwilling to testify for Thales until his death. He was so unwilling in November 2018, and that remained the position. But it's not as though Thales does not have at its disposal evidence by Mr. Thales. Sorry, Mr. Tetard.
Yes, Mr. Yes, you may proceed, Mr. Thales.
Including evidence which, if it were accepted by this court, would be exculpatory of it. And we refer in this regard to an affidavit which Mr. Tetard made on the 10th of May 2004. And it is referred to in the state's answer at paragraphs 29 to 30, and it's an annexure thereto. It's a handwritten document, my lord, and I will just give you the gist of it.
Yes, just a moment.
In that affidavit, he said that his manuscript of what when typed became the so-called encrypted facts was, and I quote, a rough draft of a document in which I intended to record my thoughts on separate issues in a manner which was not only disjointed but also lacked circumspection. And the second relevant thing that he said in that affidavit is, the so-called encrypted fax was never sent, but rather crumpled up and thrown away. So that's what he says in that affidavit.
Just a moment, I just want to go to that document because I saw it when I was reading.
Yes, my Lord. So if you go to paragraphs 29 to 30 on pages 56 and 57 of Mr. Downer's answer, 56 and 57. I'm sorry? It's paginated page 56 to 57.
Paginated page.
It's in it. I know that your Lordship has bundles, and I've lost track of the bundle number. So it's fairly early on. It's at page 56 of the papers. It's probably volume 1 of the bundle. The key paragraph is 29.
Paragraph 29.
29.
Let me just go to, yes. Let me just,
Mr. Downer's answer, which starts at page 40, paginated page 40, and at least my paginated.
page 29, yes.
And if you go to page 56, my Lord,
Yes.
the bottom of the page, you will see paragraph 29. On
Yes.
10 March 2004, he made this further unsolicited affidavit.
Yes.
And I'll take you to the annexure in a moment.
Yes.
And I've just read to your Lordship the summary from the last sentence on page 29 of what's in that affidavit. And the affidavit itself is annexure 5 to Mr. Downer's affidavit. It's in handwriting. It's at pages 496 to 499.
Right. Yes.
So your Lordship will find the affidavit there. So they have that affidavit. And what Mr. Downer also points out is that Mr. Tetard was questioned under section 28 of the NPA Act. And the transcript of his questioning is available. And the point is that Tales may seek to have that affidavit admitted and the transcript of the questioning admitted in evidence under section 3.3 of Act 45 of 1988. And in our heads of argument, we have said that in relation to that and other matter which I will identify, my Lord, that our instructions are that should Tales or Mr. Zuma for that matter apply for the admission in the criminal trial of any or all of the hearsay evidence just mentioned, including for purposes of cross-examining the state's witnesses, the state will consent thereto in terms of section 31A of the Law of Evidence Amendment Act 45 of 1988, albeit without making any admissions as to the weight or probative value to be attached thereto or any part thereof. And as the court knows, the weight and probative value of the admissible hearsay are matters to be determined by this court in its judgment on the merits at the end of the matter. You will see from paragraph 30 of Mr. Downer's affidavit, his answering affidavit in the Tali's application, that the state believes that what Mr. Tetod said in that affidavit is not true about the encrypted facts, and it itemizes the evidence that it will be leading to deal with the points that he made: crumpling, not faxed, and so on and so forth. But all of those are matters for another day. But at this stage, however, we simply point out that in relation to these two items of evidence and others to which I shall come, the state has consented on the record preemptively to their admission. So they will be admitted, and the parties will obviously lead evidence relevant to the truth of the contents of those documents. And at the end of the day, you will hear argument as to the weight and probative value of them, and you will judge that and give your reasons for your judgment at the end of the case. That brings me to Mr. Moino. Now, it is common cause between the state and Thales that Mr. Moino wasn't a central actor in the charges against Thales. Not that he was a non-entity and unimportant, but not a central actor. The central actor was Mr. Tetod from their perspective. And the reason is that Mr. Moino wasn't an officer or employee of the Thales companies in South Africa between April 1998 and the third quarter of 2001. And that is the period when most of the key events occurred. And Mr. Tetod was its local representative at that stage. He was, in other words, Mr. Moino was the local representative before April 1998 and again from October 2002 onwards. And one sees that from para 136.2 of the state's answer, pages 119 to 120. There's an incorrect reference there to 2000. It should be to 2002, for which we apologize. The correct dates for these directorships by Mrs. Tetod and Moino, your Lordship will find in paragraphs 12 and 13 of the indictment. I perhaps overstated it when I said that it's common cause that Mr. Moino wasn't a central actor. Thales doesn't admit that in its replying affidavit, but it doesn't dispute the abbreviated chronology of Mr. Moino's involvement set out, that I've just set out. And what it does admit is, and I quote, that the tenure of directorship of Mr. Tetod coincides with the period when the events most relevant to the charges took place. And one sees that at paras 112 to 113 of Thales' reply at page 673. Now, Mr. Moino testified for the defense in the Sheikh trial, and his evidence is therefore available to Thales should it seek to have it admitted in terms of section 3 of Act 45 of 1988. And what I've just said in relation to the state consenting to the admission of such evidence applies equally here. We then come to other people who could testify. My learned friend made a valiant attempt to defend his opening statement that Messrs. Moino and Tetod are the only two people who could testify for it. And we, with respect, disagree with that. He dealt with some of the others, but not all of them. First, there is Mr. Sheikh. He is a compellable witness. he cannot raise the right against self-incrimination because he's been tried and that case has run its course. As far as the state knows, he's physically and mentally able to consult with Tali's legal representatives and testified if called by them. It's clear from Tali's replying affidavit, and we're referring here to paras 60 and 62 on pages 664 and 665 of the record, that Tali's legal representatives have made no attempt to contact him or taken any other steps to ascertain whether or not he's able and willing to consult with them and testify for Tali's at the trial. Importantly, my Lord, Mr. Sheikh was a director of Tali's. He was a director until September 1999.
Just a moment. Right. Between which period?
From the commencement of that company, I'll give you the other date. It was a date in about 1995 to which I recall, but I'll get the date from my learned colleagues behind me and give it to you.
But you say till 1999?
30 September 1999. And that is deep into the period covered by the charges of general corruption, racketeering, and so on. And one need only look at cursorily at the indictment to see that the state alleges that he was involved in almost all of the events underpinning the charges against Tali's. That's Mr. Sheikh, including those relating to the period after late 2001. That is when he ceased to be a director. I gathered from the indictment at paragraph 12 that he was appointed as a director on the 1st of April 98. I misspoke when I said 1995. So he was a director for about a year and a half, from 1 April 98 until 30 September 1999. This is very embarrassing. My learned friend Mr. Downer says that I can't read. May I just take an instruction?
Yes. Yeah.
And that is? My learned friend Mr. Downer says the indictment alleges he was a director from the incorporation of Tali's in 1996 until the 30th of September 1999. And the point of all of this, my Lord, is, he was a director of this company for several years during the period covered by the Reis Gestar. And the state alleges he was involved in almost all of the events underpinning the charges against this company while he was a director of the company and thereafter. Now, it means that Mr. Sheikh should be able to provide Tali's with information relevant to the evidence to be adduced by the state against Tali's. And if that information is favourable to Tali's denials of the charges against it, it can be used by Tali's legal representatives to confront the state's witnesses, and or it can be adduced as evidence by Tali's should it elect to call Mr. Sheikh as a witness in its defence. It's true that Mr. Sheikh's evidence was rejected by the Sheikh trial court, and I readily accept that he will have a hard time of it if he's called to testify. But of course it's not unknown for people who are accused of serious crimes to give untruthful evidence, as the Sheikh trial court found that he did, and later on, when the dust is settled, and in particular when they're not in criminal jeopardy, to come clean and tell the truth, which may be exculpatory of Tali's. But no effort has been made to consult with him to ascertain any of that. And my Lord, I needn't go into great detail in connection with everything that Mr. Sheikh can testify about, because it is set out in our heads of argument. but it really applies to almost all of the charges against, to all of the charges against Thales. And just to use one example, although this is really just an example, my lord, it's assumed centrality in the argument put up on behalf of Mr. Zuma, which seems it endeavours to categorize the case against the first accused as being based solely on the encrypted facts. Yes, it's important that there are charges relating to that or based on that, 2 of them, to be precise. The most important being count 4. But that's also a charge which is mirrored against Thales. It's count 5. The allegation being that facts recorded an agreement reached at a meeting between Mr. Sheikh, Mr. Zuma and Mr. Tetard on the 11th of March 2000 in Durban, during which Mr. Zuma is alleged to have signified his agreement to a proposal previously relayed to him by Mr. Sheikh on behalf of Thales. And the proposal was in the terms subsequently recorded by Mr. Tetard in that document, the encrypted facts. Now, Mr. Sheikh can, of course, come testify to all of that. Was there a discussion of terms of what amounts to essentially a bribe agreement, a corrupt agreement between him and Mr. Tetard in the run-up to that meeting on the 11th of March 2000? Was there a meeting on the 11th of March 2000 in Durban attended by the 3 of them? What happened at that meeting, and in particular, was a corrupt agreement concluded between the Thales group and Mr. Zuma at that meeting by means of his signification, signifying acceptance of terms that had previously been discussed by Mrs. Sheikh and Mr. Tetard? Mr. Sheikh can obviously give important evidence and information about the charge of general corruption, count 2, and also the charge of racketeering. As has been pointed out, amongst other things, those charges are based on 783 payments which the state alleges were made corruptly over a period of many years as a kind of retainer for Mr. Zuma. Mr. Sheikh can deal with that. He can deal with the allegations that there was a common purpose. In other words, those involved knew, including Thales, knew that Mr. Zuma was on this retainer. And Thales assisted in achieving the objects of that by, for instance, securing Mr. Sheikh's partnership in its venture to deal with, to provide the combat suites for the corvettes, and so on and so forth. I'll leave Mr. Sheikh there, my lord. He will be a mine of relevant information, and I'll leave it at that. The encrypted facts was addressed to two, if it was indeed sent, and this is the state's allegation, denied, but it was addressed to 2 of Mr. Tetard's superiors in the Thales group of companies. Mr. Dejomaron, D-E-J-O-M-A-R-O-N, of Thales Africa, which was based in Mauritius, and Mr. Peria, a person higher up in the Thales group, who was based in Paris. That's the state's allegation. It was faxed to them. Mr. Dejomaron, in addition, signed an agreement called the Service Provider Agreement, which in count 6 the state alleges was concluded between the African holding company, the Mauritius-based company to which I've referred on the one hand, and one of Mr. Sheikh's companies, Kobe Tech, on the other hand. It was concluded as a device to conceal or disguise the payment of the bribe money resulting from the 11 March 2000 agreement recorded in the encrypted facts. So Mr. de Jomaron is the signatory to that agreement. And viewed in that context, we would make the following points. The first is that these people were the recipients of the encrypted facts, and they will undoubtedly be able to provide Thales' representatives with relevant information about what they made of this fax when they received it, and what they understood it to mean, whether they engaged with Mr. Tetard about this rather startling communication on the face of it, recording the terms of a bribe agreement. And in particular, in Mr. de Jomaron's case, the state alleges that what he made of it was, amongst other things, to go ahead with the money laundering which underpins count 6 by signing this agreement on behalf of Thales Africa with Kobe-Tech to, in other words, provide a mechanism to pay the bribe money that wouldn't be identified as such, because it was compensation for services to be provided by Mr. Sheikh's group to the French group Thales. So these two individuals are very important. The fact that they were Mr. Tetard's superiors at the time and for several years after that's also important, because of course big trouble arose very soon after the state concluded its initial investigation. Thales' subsidiary or corporate cousin, Tint Pty Limited, was charged along with Mr. Sheikh and his Nkobi groups, and then followed a back and forth between the Thales group and the state to have those charges withdrawn. You will see from Mr. Downer's affidavit, ultimately it was agreed that he would make an affidavit confirming the encrypted facts, which he did. That's now Mr. Tetard. A few days later he made this other affidavit to which I've referred, disavowing the encrypted facts. But the point is simply that these people, his superiors, the addressees of this item of information, which may become evidence in this case, must have been involved in deciding together with Thales' lawyers what its posture should be, how they should deal with this, and engaging with Mr. Tetard. It's important that if one looks at paragraphs 34 and 64 of Thales' founding affidavit in the present application, that's on pages 12 and 19 to 20, that it appears that Mr. de Jomaron and Peria are physically and mentally able to consult with Thales' legal representatives and to testify. The state drew this inference in its answering affidavit at para 136.5 on pages 120 and 121 of the record, and nowhere in Thales' reply does it dispute or let alone put up any evidence to refute it. You can compare in this regard the replying affidavit paragraph 70 and 116 at pages 667 and 676. And therefore we submit the court can safely proceed on the basis that they are indeed physically and mentally able to consult with Thales' representatives and testify for Thales if called upon to do so. They are out of the country. If they are unwilling to testify, then Thales will have at its disposal the mechanisms created by Section 2, Sub 1 of the International Cooperation in Criminal Matters Act, 75 of 1996, to effectively seek their testimony under compulsion in France, should that be necessary. Evidence on commission type evidence that can be taken. I mentioned a short moment ago that the balloon went up in around 2003, 2004, and Thales engaged lawyers. Many of them at the time contacted the state, as I've already indicated, in an ultimately successful attempt to secure the withdrawal of the charges against its co-subsidiary, Tint Pty Limited. Thales there, I'm referring to the Thales group now. But those people would have been involved in intensive work in relation to this. And I'll come to a couple of them in a moment, mentioned by the full court in dismissing the permanent stay of prosecution application. What is also striking is that Thales has put up a detailed plea explanation, denying the charges against it and substantiating those denials. And it's presumably this was possible because Thales legal representatives have had at their disposal copies of all of the exhibits in the Sheikh trial. They've had copies of the evidence, in other words, the transcript of the evidence in that trial. They have had the wealth of documentary evidence which was handed over to them in 2006 and again in 2018. And because between 2003 and 2009, when all of Messrs. Tetard, Moino, Perrier and de Jamaron were Thales Group employees, they were represented by several attorneys, one of whom, a South African attorney, Mr. Robert Dryman, as well as eminent counsel, could at the time have made the necessary inquiries as to what actually happened here. Was there corruption or not? Gather the relevant information, do a professional job. In addition, their deponent, Thales' deponent in the 2018 application, was a person called Ms. Christine Guerrier, Guerrier. She's an admitted attorney in France, and she was then a senior in-house legal counsel in the Thales Group. And she was closely involved in managing the group's response to the charges. Indeed, in paragraph 279 of her founding affidavit for Thales in the 2018 stay of prosecution application, she said she spoke to all three of the people that I've just mentioned. Tetard, Moino, and I think it was Perrier that she spoke to. And she did so in 2003 about this matter. And it would be most surprising, we submit, if she and the other lawyers involved didn't consult properly with the relevant Thales employees, take notes of what they said, and obtain and keep the documents necessary for Thales and TIN to defend themselves should it ever come to that. And this applies particularly to the period after the outcome of the Sheikh trial and the indictment of the tin companies, both of them which followed shortly afterwards in late 2005. Now, of course, what was said in those consultations is protected by Thales' legal professional privilege. And so neither Ms. Guerrier nor Mr. Dryman nor any of these other lawyers can be compelled by the state to testify about it. But it's open to Thales to waive the privilege and to seek to lead the evidence in an attempt to prove the truth of what they were told by Messrs. Tetard, Moino, de Jamaron, and Perrier. And again, in the state's papers, and this is not disputed, the state says, as far as it knows, Ms. Guerrier and Mr. Dryman are physically and mentally able to consult with Thales' representatives and to testify on its behalf if called by Thales. I mentioned, my Lord, that in the judgment on the 2018 permanent stay of prosecution application, the full court made something of this fact, and I would like to draw your attention to that in particular. This was when dealing with the Thales' claim that it will be prejudiced as the trial as the result of the non-availability of witnesses, chief among them Mrs. Moino and Tetard. And I'm referring to paragraph 156 of the judgment of the full court. It's number 10 in the state's bundle at page 240. And it's quoted in the state's answering affidavit at paragraph 119 at pages 110 to 111 of the record, and I quote, "Whilst Thales claims that it will be prejudiced in its trial as a result of the non-availability of witnesses, we are not satisfied that this will be the case, as Ms. Guerrier, for instance, who's been with Thales since the inception of the investigations, is still referred to as the Vice President of Thales in this application. The same applies to Mr. Dryman, who is also still the current attorney of Mr. Record, its current attorney of record. Now, they've changed attorneys of record, but as far as we know, Mr. Dryman is alive and practicing in Cape Town. I've already mentioned that the state will consent to the admission of hearsay evidence, and I just wish to list for your lordships, for the record, what that is. The state will consent to have admitted in evidence the following. 1. The so-called exculpatory affidavit Mr. Tettard made on the 10th of May 2004.
Just
That's
a moment.
Annexure AA5.
Just a moment. Yes.
Secondly, the transcript of his questioning under Section 28 of the NPA Act, that occurred on the 13th of June 2001.
Just a moment. Yes.
Thirdly, the testimony of Mr. Moyneau, the transcript of his testimony in the Shape trial.
Just a moment. Yes.
Fourthly, the oral testimony, and should they testify, any contemporaneous notes made by Mr. de Jomeron, Mr. Perrier,
Sorry, just a moment. Right, Mr. Chamberlain.
Mr. de Jomeron, Mr. Perrier, Mr. Dryman, D-R-I-M-A-N,
Yes.
Ms. Gurrier, or any other in-house Thales Group lawyers or external lawyers engaged by the Thales Group, and this relates to testimony regarding what Mr. Tettard and or Mr. Moyneau told them about the events which have given rise to the charges against Thales.
Yes.
In other words, Thales may seek the admission of those persons' evidence in an attempt to prove the truth of the contents of what they were told. The state will consent to that under Section 3.1a, albeit without making any admissions as to the weight or probative value to be attached there. And the last 2 points that we would then make in relation to Thales are these. As your Lordship will know, a lot of water is going to have to flow under the bridge if this trial starts. If those things turn out at the trial, due to the delay, Thales is unable to adduce evidence or challenge some of the state's evidence, and that's specifically due to the passing of these two gentlemen, Tettard and Moyneau. And if this court finds that as a result, Thales' right to a fair trial has been unjustifiably infringed, then this court will be empowered to take the remedial step or steps necessary to protect and to vindicate Thales' right to a fair trial. And without in any way limiting the generality of what I've just said, because it will be up to the court to ensure that the trial is fair, but referring back to what one of the principles laid down in the Botma and else case, as an example, if as a result of the lack of evidence, if that is where we find ourselves, this court is unable to make a clear determination of guilt, then the presumption of innocence and the state's heavy onus of proving all aspects of guilt beyond a reasonable doubt will ensure that Thales is acquitted. We therefore respectfully submit that the legal consequences of Thales' inability to adduce the oral evidence of Mrs. Tettard and Moineau, or to consult with them so as to challenge some of the state's evidence at the trial, all of this due to their passing. Those are matters to be left for decision during the trial after this court has heard all of the relevant evidence. And with the greatest of respect to my learned friend for Thales, it is impossible for this court at this juncture to determine the actual prejudice to Thales arising from the loss of these two people as witnesses. In all the circumstances, this is something properly to be measured by the court after hearing all of the relevant evidence. And so the proper course to follow at this juncture is the same as the one adopted by the full court on 11 October 2019, when it dismissed Thales' 2018 application for a permanent stay of prosecution, namely to permit the matter to proceed to trial with the hearing of evidence on both sides. My Lord, I see them about to overstay my welcome, and I need to deal with Mr.
I was
Zuma's
about to tell you
application.
that.
I will try and speed up, but I do think it's important that I just deal briefly with Mr. Zuma's application, if you'll permit. There are 4 issues that I want to deal with, my Lord. The first is Mr. Zuma's allegation that the state has misconstrued Thales' cause of action as being based on an infringement of its right to have its trial begin and conclude without unreasonable delay, conferred by Section 35(3)(d), instead of Thales' actual reliance on infringement of its right to adduce and challenge evidence conferred by Section 35(3)(i). And there's a consequent contention that the state hasn't responded to Thales' case. And my Lord, this can be dealt with briefly. With respect to my learned friends for Mr. Zuma, it is Mr. Zuma who misconstrues Thales' main cause of action. It is one of delay-induced trial prejudice. More specifically, that the deaths of Messrs. Moineau and Tettard during the delay in the commencement of the trial have irremediably prejudiced its right to a fair trial, specifically its right to adduce and challenge evidence as envisaged in Section 35(3)(i). The state has dealt with that in its answer, and I have dealt with that in my submissions today. And we would emphasize that Thales hasn't adopted Mr. Zuma's point, this one that the state has misconstrued it, or misunderstood its case. We respectfully submit that our response to Thales' application, which you've read and just heard, shows that the state correctly understood and responded to the case which Thales put up. And we would also point out the following, my Lord, that Thales and the state are on the same page, though of course we're in disagreement about the result, is evidenced by the fact that Thales and the state agree that the judgment containing the legal principles to be applied by this court is the judgment of the Constitutional Court in Botma versus else. Then there is an allegation from Mr. Zuma, this is now the second issue, that, and I quote, on a proper reading of the charges levelled against him, it's clear that the entire case is based on the notion of a common purpose to be proven via the so-called encrypted facts. That's Mr. Zuma's supporting affidavit, paragraph 68, at page 627 of the record. With respect, this is manifestly incorrect. I refer first to the charges of fraud against Mr. Zuma. Those are counts 7 to 8 and 10 to 18 in the indictment, specifically. 7 to 8 and 10 to 18. None of those is dependent on the charges of specific, is dependent on a finding of guilty on the charges of specific corruption against Mr. Zuma in count 4 and Tyler's in count 5, those charges relating to the agreement between Mr. Zuma and Tyler's concluded at the meeting in March 2000. So that the charges of fraud in count 7, 8 and 10 to 18 are separate from and distinct from let's call it the corrupt agreement / encrypted facts charges. Secondly, the court knows that there are a very large number of racketeering acts which underpin count 1, the charge of racketeering against both accused. Only 6 of the 797 racketeering acts on which the charge of contravening section 2(1)(e) of the POCA is predicated are directly related to the encrypted facts and the agreement which it records. And as regards the charge of general corruption, in other words count 2 now, only 3 of the 783 payments in the schedule to which that charge relates are directly related to the encrypted facts in that agreement. This morning, my learned friend Mr. Buthelezi for Mr. Zuma said the charge of general corruption against Mr. Zuma, in other words count 2, is dependent for its viability on the charge of racketeering against both accused, count 1. With respect, that isn't right. Count 1 requires proof of facts or factors additional to the alleged generally corrupt relationship between Mr. Zuma and Mr. Sheikh, which underpins count 2. The third issue raised, additional issue raised by Mr. Zuma, is his allegation that the deaths of Messrs. Moino and Tetard are fatal to the state's case, with the result that, and I quote, "It has now collapsed and can only run on speculative permutations from this point on." For this, with respect to my learned friends, for the following reasons, this allegation too is manifestly incorrect. And we refer in this regard to the state's answering affidavit, paragraph 159 at page 841. The first thing about the, in response to this allegation, is that it is premised on the earlier allegation by Mr. Zuma, which I've just addressed, namely that the state's entire case is based on the notion of common purpose to be proven by the so-called encrypted facts. But that too is manifestly wrong. And what is more, as explained earlier when I dealt with Thales's application, the effect of the passage of time on the availability of evidence has been limited by the fact that the matter was well investigated by 2005, 2006, the wealth of documentary evidence, etc. I've already dealt with the state's intentions in relation to Ms. Delik's evidence and the admission of the encrypted facts, and I have nothing to add to what I've said in that connection. I would, however, point out, with reference to paragraph 30 of Mr. Downer's affidavit, answering affidavit in the Thales application, that the state will lead a range of evidence which corroborates Mrs. Delik's evidence at the Sheikh trial, as well as the contents of the encrypted facts. And I won't go through them now. Your Lordship will find the various items of evidence listed at paragraph 159.6 at page 843 of the record. All that is presently relevant about the so-called House of Cards collapsing contention is that when it comes to deciding on the admission of the hearsay evidence of Delik and as contained in the encrypted facts, one of the crucial factors, as the court well knows, will be corroboration. And the state intends adducing various corroborating evidence of different kinds. That brings me to Mr. Zuma's final point, which is that, as I quote, the case against him and Thales is, and I quote, symbiotically conjoined and therefore cannot be artificially separated. I have to say, I detect the hand of my learned friend Mr. Mpofu in that sentence. To put it simply, it's in my view, it's in my view totally impossible for the state to pursue the case against me if indeed the prosecution of the second accused must be terminated upon the pleaded grounds, as it must. And the reason he gives, and I quote, is, the deaths of the two material witnesses had a similar or equal effect on the evidence necessary to convict me. There are just a couple of things that we wish to deal with. The first is that we note from Mr. Zuma's supporting affidavit, paragraph 61 at page 625, that he believed when he made his affidavit that Mr. Moino and Mr. Tetard are on the state's lists of witnesses, and hence his contention that they would be denied the opportunity to confront their evidence because they've now died. Well, they're not on that list, and we heard a rather more muted submission this morning to the effect that, well, if they had been alive and had been called by Thales, then, and if they had then given evidence which was antithetical to Mr. Zuma's case, they could be cross-examined. But it's a rather considerably watered down situation to the cases to which you were taken, where crucial state witnesses started and then stopped testifying before being cross-examined, and the evidence was nevertheless admitted, etc. Be that as it may, but the big point really is this, and this is my final point, my lord. We have an allegation that essentially that Mr. Zuma and Thales are identically situated. And I wish in that regard to respectfully remind you of a submission made by my learned friend Mr. Rue for Thales early on, and that is that his accused is a corporate entity. It has no mind of its own or mouth of its own, and so on, and it's reliant on people to speak for it. Mr. Zuma, of course, is a natural person with all of the attributes to which I have mentioned. And if one looks at the indictment, it's clear that the state alleges that he personally was involved in the alleged racketeering, the alleged corruption, and the alleged frauds. In other words, all of the charges which have been leveled against him. And of course, he is alive and well. He was here in court this morning. He may still be, I don't know. And it's open to him to instruct his legal team. It's open to him to testify in his own defense, as Mr. Sheikh did in his criminal trial. To give one practical example, he may testify as to whether he attended a meeting with Messrs. Sheikh and Tetard in Durban on the 11th of March 2000, as the state alleges that he did. And if he did, whether at that meeting he concluded a corrupt agreement with the Thales Group, as the state further alleges that he did. So with respect, we submit that Mr. Zuma's case, based on section 35(3)(I) of the Constitution, is, to say the least, unpersuasive. The state accordingly prays for the following relief. Firstly, that Thales' application for relief in relation to section 6 of the CPA, or as it's now amended, declaratory relief, be dismissed, and consequently that Mr. Zuma's application for similar relief be struck from the roll. Alternatively, that both Thales' application and Mr. Zuma's application be dismissed. Lord, there's one matter which I must mention before I take my seat, and it is what happens after today. And we have discussed this with our learned friends, And I'm not saying that there's agreement on what I'm now going to put you. I'm mentioning it now so that they can reply. The state's respectful suggestion is that this matter be postponed to a date for judgment on these two applications. The court will know that the parties have indicated their counsel's availability in the week of the 12th of May. Secondly, depending on this court's judgment, at that date there will have to be a further discussion about what next. I don't want to say any more about that at this stage. The third thing is that the state, again this is a matter for the court to decide, but the state says it has no difficulty if your lordship, when postponing the matter, were to for judgment on this application or these applications, were to indicate that it is not necessary for Mr. Zuma to be present in court on that date, on judgment date, or for the representative Charles to be so present. Unless your lordship has any questions for me, those are the suggestions for the state.
Even if I did, we have run out of time. Yes, thank you. Yes, yes.
I'll stay within that little bit of time that I have.
Thank you.
Well, the main difficulty with this matter is once there is insurmountable fair trial prejudice, it does not matter whether a serious and whether another extremely serious case goes to trial, because we are a constitutional state and it reigns supreme. If you have to balance their constitutional rights with society's right to bring an offender to book, and there's an unfair trial, the unfair trial will always reign supreme. That is the protection that we have in a constitutional state. The second part is the state's contention that lawyers can give evidence. It's cold comfort. I've just realized I'm a compellable and competent witness for Talis. I don't know what I'm going to do in court, because I have consulted with witnesses and they won't accept the probative value, because they make clear they won't accept the probative value of my hearsay evidence. So I'm not sure what the value is, but for nil. That's the difficulty. And it would open a floodgate that all lawyers will then become compellable witnesses in their cases. The point about Mr. Tatar's willingness to testify, we've dealt with and said it must be read in context. You will refer to the handwritten affidavit, AA5, and you will see in the last paragraph there. That was page 499, my lord.
Yes. At page 499.
499. And that's the context that I keep on saying. He didn't want to give evidence in South Africa. We know there were warrants at the time against him. They subsequently withdrawn. But he says that for reasons that I do not propose to traverse in this affidavit, I refuse to be or testify, that's interview or testify in South Africa or any other country outside France. It's not,
So just a minute.
he's willing to give
In any forum in France.
outside France. He says he will give evidence in France. That's
Okay.
that's a short sentence.
I'm very sorry to interrupt my own friend, but I would like him just to consider carefully if he's reading from the right affidavit. I did see that point made in the heads of argument, and there was an affidavit earlier in which he said that, and then his position hardened in a later affidavit, which is the one which was attached to the 2018 application.
Yes.
No, I know that mistaken, that we referred at some point to a wrong affidavit, that's true. But this one is the one that the state referred to. It's exactly the same with the handwritten one. It's page 499. He referred you to the top part of 499, we refer you to the bottom part of 499.
Yes, yes. That's paragraph 8, isn't it?
It's the extension of paragraph 8
It's an
indeed. Yeah.
extension, yes, yes.
You will refer to the top part of paragraph 8 and I refer you to the bottom part of paragraph.
Bottom part, yes, yeah.
Yes. As to the leak,
I see, right at the bottom. For reasons that I do not propose to traverse in this affidavit, I refuse to be interviewed or testify in South Africa or any other country outside France.
Outside France, he's prepared to do it in France. My Lord, the reference to the leak exposes a further insurmountable pre-trial trial prejudice, because the state says they're going to apply for the leak evidence to be admissible. Now, the one person that would have been in a position to refute the leak's evidence is the tart. It's no more. So then it's more than, then they bring in hearsay evidence where they say is admissible for whatever reason, and there we are. Naked again. The tart would have said something about it. Further point, they're saying you were in a position to do your plea agreement, your plea explanation. I think the plea agreement's a Freudian slip. The plea explanation. The tart was alive. At that time, it was not dead. The relevance of Manoy. We understand this relevance is not related to the specific corruption, counts 5 and 6. His relevance is he was the first representative of Thales in South Africa. So if that common purpose that they say existed from the beginning, that he must have then been a core party to that. And that was then followed up by Mr. Tetart to say, we enjoy that common purpose, let's carry on with it. So he's extremely relevant in relation to those charges. Just maybe one correction, and that is the payments made by Mr. Sheikh did not come from Thales. If there's a statement like that, it's not true, and that's also not the state's case. Those 783 payments. The only payment that's the disputed payment is the specific corruption. Whether that was made to Mr. Zuma, but I'm not getting into trial dispute, that's unnecessary. The court will just bear with me, I'm trying to be within the time. I see the lateness of the day.
Otherwise, I'm going to miss your flight.
Yeah. My Lord, the last point is, and then I'll be very quick. My Lord, the statement that, well, let a trial run and then the court can determine the pre-trial prejudice. But that's with respect lip service, because you know what the problem is. We all know what the problem is. It's not something that will change. So that sounds wonderful, but it's lip service, my Lord. Because we are at point A to Z, and A to Z will remain. Unless Mr. Tatar changes his name to Lazarus, but short of that, it cannot happen, my Lord. Thank you, my Lord.
Yeah, okay, thank you. Yes, Mr. Mpofu?
Thank you, my Lord. My Lord, you know, I think let me start where Mr. Rue has left off. That Your Lordship knows the law in general regarding stay of prosecution, that one of the considerations is, for example, the possibility that, you know, the delay may be ameliorated, let's say by finding other witnesses and so on. Now here, the delay cannot be ameliorated, say for the situation of the biblical Lazarus, where Mr. Moino and Mr. Tetar and Mr. Van der Waalt and Mr. Leek will be resurrected. So that's where we are. So there's no possibility of this situation changing at all. But my Lord, let me maybe start here. Again, I'll start where Mr. Breitenbach left it off before I make my other submissions. He made 3 submissions towards the end, which are, to say the least, startling and bizarre. Firstly, he says that the mistake we made, which we have considered, that Mr. Tatad and Mr. Moino were on the witness list of the state, is now, now we have a watered down version. Because now we're saying, well, when they are called by Thales, we will cross-examine them. I mean, that's completely bizarre. What difference does it make? Section 166 says that we have a right to cross-examine the witness. Whether that witness is a state witness or called by Thales, we have the same right. So what difference does it make whether it's called by them or. So our right to cross-examination, which we lose, is the same, whether that statement would have been called by the state or by Thales. So I don't understand where the watered down is. Then he says, my Lord, that, and is correct, the difference between Thales and Mr. Zuma is that Thales is a corporate entity and Mr. Zuma is a natural person. Now, this is very true. But this makes Mr. Zuma's situation worse than that of Thales. We know that in terms of Section 332, even if Thales had killed 1 million people, the only thing that the court can impose is a fine, because it's a company. But in the case of Mr. Zuma, whom Mr. Breitenbach says was here alive and well, he stands jeopardy of being imprisoned physically. So how is that something that works against Mr. Zuma? So something that works in favor of Mr. Zuma, that he can be expected to undergo a fair trial. Maybe Thales can be expected to undergo a fair trial, an unfair trial, because after all, they'll only get a fine. But certainly Mr. Zuma cannot be expected in a constitutional democracy to undergo an unfair trial. And then the one that takes the cake, Mr. Breitenbach says it's open, it's open to Mr. Zuma to testify. In other words, to bolster the state's case. But what is that? Of course, it's open to Mr. Zuma to testify, but he has no legal duty to do so. And this case will never go even past Section 174, quite frankly, as Mr. Rue said in the morning. They can do all these tricks and if this, if that happens. And then Thales will just say, well, thank you very much. We're closing our case at the end of the state's case. And we'll be exactly where we are now. So the question simply is whether your Lordship must wait to reach that stage, which is predictable and it's going to happen because we're not going to resurrect these witnesses. Or whether whether Mr. Breitenbach is correct in saying, and I quote him verbatim, it is impossible for this court at this juncture to assess the amount of prejudice. That's the question. How can it be impossible for this court to assess the prejudice when that prejudice is not likely to change, whether it's done now, whether it's done at the end of Section 174 or at the close of the state's case or whatever. It's clear now that the trial will be unfair. Then, my Lord, Mr. Breitenbach criticizes our case that the case of the state has now collapsed and can only run on speculative permutations. That's the gist of our case. If you know, if you did those Google things of searching Mr. Breitenbach's address, the most prominent word will be if. Everything is if. And that's what you mean by speculative. That the case, the remaining case of the state is now based on pure speculation. So, first one, if the hearsay evidence of Mr. Leak is accepted, then there'll be a fair trial. That's what they say. If tellers can find Mr. Sheikh, then there'll be a fair trial. If tellers, having found Mr. Sheikh, whose whereabouts are unknown, decide to call him, because remember, they can find him, interview him, and find that he doesn't assist their case. If they decide to call him, if tellers waives its client's attorney privilege, if the accused testify in their own defense, never mind the owners, and if the potential witnesses made contemporaneous notes, and if the court can somehow separate the Siamese twins that these cases are between these two accused, all those ifs, well, then of course, my lord, you can have 100 ifs here. If, then we'll have a fair trial, great. Yeah, but what if not? So, to sum up the state's case, my lord, he says the elephant in the room is Mr. Tetad and Mr. Moino. Well, the elephant is not in the room. The elephant is in the cemetery. And that's it. Until the end of time. Now, yeah, okay, here's the other one. So, Sheikh is supposed to be compellable. So what if let's assume everything I've said is wrong. Mr. Rue, in a moment, a lapse of forensic skills, calls Mr. Sheikh. And Mr. Sheikh, so what's Mr. Sheikh going to say about what Mr. Rue was reading? Where Mr. Tetad said, this fax was never sent. I crumpled it up and threw it in the dustbin. Somewhere in France or whatever. Is Mr. Sheikh going to say, no, Mr. Tetad is wrong in that affidavit? He didn't. He actually sent the fax. I mean, all right. Then, you know, there was this little hachi-pachi between Mr. Rue and Mr. Breitenbach just now. But whether is this the correct facts from Tetad and so on, that is the exact manifestation of what we have here. So that relation, whether that's the first facts from Mr. Tetad or the second one or where he retracted and so on, who's going to resolve that if Mr. Tetad is not here? So that's the whole point. And remember, my lord, at least one of the versions, sorry. Yes, this facts. I'm sorry. This affidavit of Mr. Tetad that we were talking about, and I'll go through this very quickly, my lord. Let's go to 498.
The handwritten one.
My lord?
The handwritten one.
The handwritten one, my lord, yes, which starts at 496. It's Annexure A5.
Yes.
And while your lordship is looking at it, let me just make this submission that if we are disputing all of this, what must we do? We must cross-examine a piece of paper. So he says, I'm reading at 496. 496. Yes, that would be an annexure to the to the AA
Right,
of
paragraph.
in the second.
Yes, which paragraph? Which paragraph?
Paragraph. Let's start at 4. I'll just take a few selected ones.
Yeah.
So it says at 496. At this stage, I wish to state that I do not agree with the interpretation accorded to Annexure X by the state. That's the facts. Furthermore, the state seeks to draw inferences from Annexure X which are not justified. I won't even go into the detail. Let's just jump to another one. Then paragraph 6 says, at no stage did Mr. Sheikh ever request from me or in my presence the payment of a bribe to the Deputy President by Thompson CSF, that's Mr. Zuma. At no stage was there any meeting or discussion with Mr. Sheikh or Deputy President where the payment of a bribe featured, even remotely in the meeting, and so on and so on. In the same vein, let's jump to the next one on 499. The document annexure was never, to my knowledge, instruction ever faxed. It was merely a rough draft of a document which it goes on in that same vein, yeah. So we know that there's another fax, another affidavit, but the point of the matter is which one, they have the same value now that the writer thereof is no longer there. We all know that we all cross-examine policemen. Oh, you said this and this, now you're saying this and so on. That is exactly what we've been denied, which will never happen now in this case. And that's incurable, as it were, save a biblical miracle. Then, my Lord, I just want very important. And I'm not going to develop this point, but my learned friend talks about issue estoppel and res judicata and so on. Well, if I know that we've run out of time, but if my learned friend has any authority that shows that in a criminal case you can raise issue estoppel, then I will give him, I'll eat my hat. Because, my Lord, surely, if there's been an infringement of criminal, or rather of constitutional rights and the denial of fair trial rights, you can't say, no, you can no longer, you can't invoke that because of issue estoppel or res judicata or all those things. The only way you can meet that case is Section 36. I won't develop, I said that in the morning. So this is not, this cannot assist them at all. And in any event, my Lord, let's assume, for argument's sake, that the case, that they are right, that the case for Thales is the stay of prosecution. We know that that's wrong, but let's indulge them. Your Lordship knows that even in a case of stay of prosecution, you are not barred forever, amen, if new facts arise from bringing another stay application. So where would the res judicata feature? Even on that case, if there are two things, there it was said that these people are sick, now they are dead. And it was said, especially in respect of Mr. Moino and his Alzheimer's, there's no medical evidence. Now there is medical evidence of their death. It's called a death certificate. It's here. So even if those civil law defenses applied in criminal proceedings, they would not be applicable. Next point, my Lord, is sorry, I want to end with this one. Oh yes, no, we've already said the thing about that this is a trial court. Then, my Lord, with the greatest respect, Mr. Breitenbach, and it's really, Mr. Breitenbach actually says that there are two cases that have been pleaded by Thales. He says there's an amended case. So the amended case is the one about Section 172 and Section 38 and so on. The original case, he says, was about section 35, 342A, big A. Well, Mr. Roux, in his defense, has this, well, it's not him, it's his attorney who attested to the original affidavit. But like my learned friend, I can see Mr. Roux's hand in this. Yeah. So their case, my lord, has never been amended. You'll find their case at paragraph 74 at page 28 of the papers. From paragraph 74 to the end of that affidavit at page 31. And I paraphrase it as follows. Now, just to show that it's actually what Mr. Breitenbach is accusing them of is the exact opposite. Here they say, my lord, at paragraph 74, our case is based on 35.3i. We've gone through that. And then here, where they talk about the section 36 thing, without mentioning section 36. In the event that it is compelled to proceed with the trial, its constitutional right to a fair trial will have been unjustifiably infringed. In other words, infringed without the section 36 justification. And then they say at paragraph 78, in terms of section 38 of the Constitution, this is in chief, there's no amendment. The second accused has a right to approach the court in instances such as this, namely where its rights to a fair trial have been infringed, threatened, and the court may grant appropriate relief. And then it says, second accused submits that this application is within the domain of the court, should be considered before proceeding with the criminal trial, as it would be unfair and a breach of the constitutional rights should it be compelled to participate in a trial in circumstances where its constitutional rights to adduce or challenge evidence has been infringed and cannot be remedied. And then here's the $1 million one. They say the exact opposite of what they are accused of at paragraph 81. In this regard, section 342A of the CPA contemplates where a court made orders eliminate delay. In this particular instance, however, an elimination of the delay will not reverse the prejudice which has already been suffered. As such, section 342A of the CPA does not provide for appropriate relief for the infringement of constitutional rights to a fair trial to adduce and challenge evidence, as envisaged in section 35, 38, and 172. That's what we all interpreted their case to be. So where's the amendment? And then in the last paragraph, it is respectfully submitted that the relief sought is the appropriate relief and just and equitable as envisaged in section 38 and 172 of the Constitution. That's it. So the wrong case that they answer is not by some amendment. The case has always been that there's a breach of section 35, and therefore it invokes section 38 or 72. Finally, my lord, for what it's worth, the so-called Stalingrad thing. Now, I'm going to approach it differently now, my lord. From the point of view of the what we call the whataboutism of the state. So they say, your lordship knows there's a whole shopping list. Well, if you didn't challenge the spy tapes, the trial would have finished. If this had happened, and I don't know absolutely where Mr. Breitenbach gets this, except from him basically saying it from the bar. Had they not done so, in other words, had they not challenged any of those things, the trial would have finished before the death of the witnesses. So says who? So let's assume the section 106 point had not been taken. Mr. Moino died in 2020, the other one in 2022. Who said the trial would have been finished? Let's assume there had been no section 106. There's no such thing. That just comes from Mr. Breitenbach's mouth. Where what it's based on is a mystery. So that's another pure speculation. But the whataboutism, my lord, must be killed by this point, which is my last point. If your lordship goes to page 257, the real whataboutism is just that the state is disingenuous, to put it mildly. So when they do the chronology, and that's why my learned friend, Mr. Rue, this man, I don't know if he handed it up, he had prepared a chronology. Now, when you have a case where there are two chronologies about the same thing, then you know there's a problem. That's because the state's chronology is so doctored. It has major omissions which are deliberate. So let me give you a few examples. It omits the fact that on the 21st of September in this court, well, the one next door, the fact that he was arrested in the first place after the plea, arrested for unrelated issues. And that obviously had an effect on whether that trial could start. But more than that, and for me this is personal because that's actually when I got involved in this case. Then on the 21st of September, my lord, standing here on that door, Mr. Zuma was in some prison or hospital. And he had a right for this person who wants to delay the trial. He had a right to say, no, I want to be present. But you know, there was COVID and this and that, the other. Mr. Zuma instructed me personally to say, let the matter proceed. If you go to the record, you'll find Judge Kuhn even said, Mr. Mpofu, are you sure? I don't want later for you to complain and say, you know, the accused was not here. And I said, no, my lord, I've got permission from Mr. Zuma that the matter cannot be delayed any further. All those things are omitted for convenience. The fact that Mr. Zuma, on the 26th of May, when I first came to this court, said to this court, please, you must adjudicate both my Section 106 and the removal of Mr. Downer together. And the state said, no, you can't do that. And that's why your lordship is now settled with that case. Otherwise, it would have been resolved before Judge Kuhn. No, you're not told that. And a whole host of other things. But here's the crux, my lord. Forget all this 100-page chronology. Let's engage in the whataboutism that the state wants. If what is at page 257 had not happened, there you'll find that Mr. Downer says that their team, the DSO team, looked at the evidence and then they found that, I'm quoting, the evidence had tended to confirm the contents of the encrypted facts. That shows the centrality of the facts, as Mr. Butele says, were true, and also showed that Zuma and Sheikh had a generally corrupt relationship, and that Sheikh's payment to on behalf of Zuma had been made corruptly. The investigation team accordingly recommended that NPA institute criminal prosecution against Mr. Zuma along with Mr. Sheikh. In other words, the investigating team recommended that Mr. Zuma be prosecuted along with Mr. Sheikh. Now that's the real whataboutism. So let's think, if that had happened, the trial would have been finished. That one is not speculation because we know that the Sheikh trial is finished. So what happened? He says the officials appointed decided not to accept the investigations team's recommendation to prosecute Zuma. In their view, whilst there was a prima facie case of corruption against Zuma, the NPA's prospects of success were not strong enough to prosecute him. Now imagine that was before the deaths of all these people, and they felt that their case was weak. But now suddenly it's strong after the 4 or 5 deaths. I'm told Mr. Kevin Woods has also since left us. So then, my lord, if you go to page 262, it then says, in the afternoon of the 23rd August 2003, Ngcuka and Maduna held a media conference at which Ngcuka announced the NPA's decision not to prosecute Zuma. I was present. Ngcuka read out the said that whilst there was a prima facie case of corruption against Zuma, the NPA had decided not to prosecute him because it was not sure of his prospects of success were strong enough for a winnable case. That's the whataboutism. So all these other things that has subsequently happened, Section 106, encrypted facts, and what do you call it, spy tapes, and all those things, would have emerged much later after we know for a fact that they emerged after the Sheikh trial. So if they want to engage in that whataboutism, they must start there. It was their decision, not ours, not Thales, for not to include Mr. Zuma in the Sheikh case, in which case we know for sure, not as a matter of speculation, that the trial would have been concluded.
That was your last point, Mr.
It was, my Lord. I'm just looking through it. Yes. Well, sorry, my Lord, I can't resist this one. Mr. Breitenbach says that his reasons for saying this is the same as the stay of prosecution, I've never heard this, is because the remedy that was sought in the stay of prosecution is the same as the remedy that is sought here. I mean, honestly. So that means if I bring a case based on jurisdiction, the remedy I'm looking for is dismissal. And I bring another case now based on locus standi. The remedy I'm seeking is also dismissal. Then I say, no, it's the same case because you want the same remedy of dismissal. What is that? The point is that this is not a stay of prosecution. Stay of prosecution means something technical in law. It's not the same thing as just an acquittal at the end of the trial. And it's reversible. We know all the qualifications. So, my Lord, the very theory which you'll find at page 140, I won't go there because of time, page 140 of the papers at paragraph 192.1, where they effectively say this case is the same as the stay of prosecution. That is the end of this thing, because it means that they are answering to the wrong case. It's not the case pleaded by Thales, it's not the case pleaded by us, it's a case invented by them of 342A. Thales has said this is not 342A, we have said this is not 353D, but they say it is. And therefore they've answered their own case, hence we say the real case is unopposed on that basis. Sorry, my Lord. Yes. Okay. Well, I'll summarize, my Lord. The question. I think I've already said this. The 35(3)(I) case, therefore, is left unanswered. But on a more serious note, the case, I was listening to what will be the response to Mr. Buthelez's response analysis. Well, there was none, quite frankly, because Mr. Buthelezi painstakingly showed that these charges, although they are separate for obvious reasons, actually flow from the encrypted facts and the racketeering and so on. And I said this morning, we'll wait and see what the response is to that, to address it. Well, the response was 0, and therefore our reply is 0. Let's go, please.
Yes, can I have your comment, both you, Mr. Mpofu, and Mr. Roo, on a suggestion that was made that the matter be adjourned to a specific date? What do you say to that?
Well, Lord, we have no difficulty. We just did not want to put constraints on you as to
Yes,
suggest a
certainly.
date. That's for you to decide, because we're not writing a judgment.
That we want
But, yeah,
our judgment by this date.
No, my Lord.
And if that doesn't happen, I'm
that-
taking you to the chair's seat.
That's why we did not participate in that conversation. But we agree that it be postponed to a date that the court will give us whenever that is, and just ask that the representative of Thales be excused for that date,
Yeah.
whenever that's a suitable date.
Yes,
The
Mr.
court can
Mpofu.
even let us know about the suitable date, postpone it sine die, and then give us a date, the same thing.
Well,
Mr.
yes, I was, my little friend has taken the words out of my mouth. Well, we certainly cannot be party to putting a gun on your lordship's head. This is a complex matter. Even according to the other side, it's novel. It's novel, and that's self-evident. So your lordship is going to have to apply his mind without any gun over his head. But we know the provisions of Section 168 of the Criminal Procedure Act that it has to be postponed to a specific date.
Yes.
So, quite frankly, my lord, one can what we normally did in this trial is to put it into some date which is not too far off, and then on that date, if and when the judgment is at hand, then we will deal. Otherwise, your lordship will simply postpone it again.
Right.
Yeah.
So what date did you have in mind? Was it in May?
No. That would be too soon. The date of May that my learned friend is talking about is you remember we wrote a letter to your lordship. They wanted the matter to be this week. We wanted it to be in May then, but your lordship elected this date, so that date is no longer relevant because it was overruled by your lordship. Mr. Butele says 3 months, but my lord, it really doesn't matter. It could be any date in. Yes, we'll make a plan, my lord. Put it this way, my lord. What Judge Kuhn used to call these things holding dates.
Yes.
So we'll have a date like that. Yes. Quite frankly, it can be any date, end of May or beginning of June or whatever. Because remember, that will be a date where your lordship either is going to be handing down a judgment. Yes. If it does, we don't all have to be here. We can send juniors or we can send our attorneys. We can only be here for the purposes, but that can be done by correspondence of then determining the next date. But as knowing these parties as I know them, but if by that date there's an agreement on some arrangement, we will write to your lordship. Even if there isn't an agreement, we'll say this one says this one says that, and then your lordship can
all right, let's adjourn it to a holding date that then as you say, holding date. What date do you have in mind, Mr. President? Sometime in May.
What I mentioned
during the course of the session. I know I'm doing civil duties in May, but I will be able to accommodate.
Thank you. We mentioned the week of the 12th of May for the reason given, namely that the parties had discussions and everyone is available in that week of the 12th of May as a possible date for the hearing of today's matter. I must just make it absolutely clear, if I didn't do so in my main address, we are not trying to put a gun to your lordship's head. We realise you've got to consider the matter and deliver a judgment. But we're also mindful of the fact that this is a criminal case and Section 168 requires you to postpone it to a date.
To a specific date, yeah. How about towards the end of May?
Towards the end, yes. That's what I was about to say. Can I just make a special request, my lord? Yes. That date be after the 24th of May. And I'll tell you why, my lord. Because today is the 24th of April. And therefore we have to do the petition. We have a month, as your lordship knows. So if it can be after that, then we can appraise. At least we can appraise your lordship as to what has happened with that. So just for our convenience, the end of May. I've completely
forgotten about the fact that you are on the 24th.
My lord, this case, one mustn't forget these things here. I know it has byways and highways here, but it would assist us, because then we would at least report back to the court as to what would have happened. It's just a convenience. The court is not convenient.
Well, let's adjourn it towards the end of May then.
Yes.
Let's find a date towards the end of May.
No, I can't do that week. First
Lord, if it's on the basis that on that day either your lordship will deliver the judgment or postpone it to another day while your lordship's still considering this matter, we will ensure that someone from the state side is on any day that you choose towards the end of May. So we will fall in with whatever would suit your lordship's convenience.
And likewise, we will make sure that someone is here.
Well, I promise you I'm not shifting the goalposts, and I know that I have an arbitration in the last week of May, so we could make it even the 1st of June or whatever, but it shouldn't make much difference. The 3rd.
3rd of June.
Yes.
Right. Is that not recess period? Is that not recess period?
No, not yet. I don't know about this division, but it should be.
Right.
But even if it is, if your lordship, if you are not overburdening your lordship, it's just the delivery of the judgment.
All right. 3 June it is then.
The recess starts, as far as we know, on Sunday the 22nd or Monday the 23rd of June.
Yes, thank you.
All right, this matter is by agreement adjourned to the 3rd of June 2025. It's a holding date. Mr. Zuma and a representative of Thales do not have to appear on that day. Judgment is reserved. Court adjourns.